All right, welcome, and we are live. So I'm back after a week long hiatus. Dolores, welcome. Thank you for tuning in tonight. So we've got a couple of topics. Um, like I said, this is my first one back in the saddle since the passing of my father. Um, Sad times, sad times. It was unexpected. Um, I was actually live on a stream, and I got a phone call from a family friend who was supposed to be having lunch with my dad. And you see my ringtone, which is the Rocky theme, went off and went off twice. And I kind of started to realize that there's a problem because I knew this individual wouldn't be calling me multiple times if it wasn't. And got off stream and ended up going over there, and we found my father. Unfortunately, he was passed away in his house. So it was not expected. So there'll be more to come on my dad to tell his story. He has a very interesting story. Um, I hoped he would be telling it with me on here as everybody got to know him. As I call him, the Oracle. He's the one that's the source for all of my um, when I have a question or a legal question about something or to try to understand a concept, I would go to him, and he would, you know, always make it easily understandable. And we were going to be introducing him in the Crumbley case. That was the case we had planned because one of his things that he likes to focus on is on due process issues, and we believe we identified one in that case with the way the appeals court was justifying um, charging the Crumleys, and we were going to be bringing that out. Now, I'm still going to try to do him justice, and we'll talk about it as we go out. But it won't be the same without having him. Like I said, it's a huge loss, tremendous loss. But I've still got lots of preparations going on. But I decided I got to get back on the horse. I'm going to come out tonight. And of course, it's just been real sensitive too because the law, everything about the law, trials, and everything reminds me of my dad. So it's kind of an emotional thing. But today, I went and saw him finally because he's going to be cremated, and then we're going to be having a memorial service for him on the 16th, where a lot of lawyers and things, people he worked with, and all that stuff are going to be coming out and paying their respects and telling stories and doing doing things like that. So that I'm in preparation for that. But I thought, you know what? I got to get back. I can't guarantee I'm going to be here every night at this point because I'm still doing a lot of stuff in preparation for that event. But I'm going to try to be coming on here, especially now that the Crumley case is on. We've moved past the Russ case. So we're going to break it down because actually, believe it or not, the Russ case is a great segue into the Crumley case because there's a concept that's present in the Russ case that is something that the jury needs to understand, or we hope that James Crumley's attorneys will ensure this jury understands it better than Jennifer Crumley's jury did, because it was, and that concept is foreseeability. So we're going to be discussing that tonight. We're going to watch a clip of the closing argument where Hannah Gutierrez's attorney did an excellent job explaining that concept. We'll watch the verdict, and then we'll move on to James Crumley, and we'll get into the first day of trial, and we'll kind of talk about that. May look at some other things. Like I said, remember, this is about interaction, so you guys can take over, ask me questions, comments, whatever. Um, you know, everyone says it, but genuinely sorry for your life. Yes, it is. Uh, yep, yep, that's what I'm doing, Dolores. I appreciate that. It is. It's tough. It really is, but it's really tough. Um, really tough. Let's see here. I know it's nothing to do about the Chroma case, but how? Ty Tucker. Okay. So, update on Ty Tucker. We can definitely get into that. Ty Tucker will be back in court on the 11th. So, that will be, what's today's date? Today is, I think, the 7th. So, we're talking 8th Friday, 9th, 10th. So, on Monday the 11th. Now, I don't know that is going to be Um, I don't know. I don't know that that's going to be televised or not because it's a status hearing that's going to be done by phone. And Eon, my dad passed away, and he was going to. Well, he and I had crafted this channel together, and we're working on it together. And part of it was going to be to tell his story, which I'm still going to do, but it'll be without him. But he was an elderly. He was 75, going to be 76 in April. And as his story gets told, it will become clearer about just everything that's surrounding all that. We're going to tell it all as we also cover trials and do things. But he passed away. In fact, I was live on air covering the Rust case, going live when I got the phone call, and I had to keep my composure, get off the air, and I kind of went silent for a couple of days because I was dealing with a lot of different stuff. And it was just quite a surprise. So we're just kind of taking it all in. But yes, on the Tyrone Tucker front, now it's a status hearing, so it's going to be basically more like a scheduling hearing. Now, basically, the understanding is right now is he's awaiting transcripts. So that's why everything's on freeze. That's why you haven't really heard much. That's why there's been no further motions. There's going to be one issue that's going to be taken up on Monday, and I want to do Ty Tucker justice. I'm working on uh, a piece explaining the gag order that they had in place before to try to get the information out, and I want to have that out by this weekend before he goes to that status hearing because I just want it out in the open what they did, what the purpose of it was, and the way they used that to help get people to understand what he's up against. Because if they reinstate that gag order again, that's going to be a really, really bad thing. And it's especially bad because they attempt it, and who knows, they could try to gag somebody like me or somebody that's just reporting on his case. Because what they did before is they not only gagged Tyrone Tucker, but well, you know what I'm saying? The judgment of acquittal because it was a mistrial that's no longer possible. He's filing for a motion to dismiss. So what he's doing is he's reopening his motion to dismiss essentially now that the trials happened and he's got other evidence to bring in and he's got various different things. He's reopening it up and with a new judge and asking the new judge to reconsider the motion to dismiss, which he's allowed to do because there's a new judge. But to do so, in order to complete the case, he's got to get the transcripts, and then he wants to bring that information, some of the information that was in there. Well, no, that was actually not correct. That's what the state said. It was actually 8-4, but it was 8-4 guilty, from my understanding. So yes, and if you look back, I had covered. Remember, we had watched that. I think it was the second episode. We watched the court TV coverage where his wife was on there, and she even said after the verdict that his two attorneys, Jerome and I can't remember. It's slipping my mind what the other what the lady's name is, but they want to try this case, and I believe absolutely they would win this case. I mean, the thing is though, I think Tyrone wants this, and again, this was understood at the other side of things. Tyrone, the way he sees it is this: he understands that a good attorney could come in here, argue this case, and beat this case, and it would be a reasonable doubt situation. I mean, just arguing simply that they can't meet their burden is enough. I mean, he really wouldn't have to put a witness on. It's that weak. All you would have to do. No, I did not, Ian. I have not seen a jury interview. I wasn't even aware that one had been interviewed. I need to check on that because that would be very interesting. Did they say anything interesting? But I think what his goal is, and again, this is just, I'm not trying to speak for him, but I'm just interpreting things I've heard him say. I believe that what he's attempting to do is he wants to use his trial and all the media attention that it's garnered to not just get an acquittal, but he wants to use it to get this information out there. The problem he's running into right now is that, and I will do that. The problem is that he's running into is his attorneys will not agree to do that. So that's a problem. So what he's trying to do is do it himself. He understands the risk. He understands the risk of what he's doing. And okay, here we go. Let's see. Let's find the entirety one. So I see juror speaks out. Let me make sure. Let's just see. Channel 7. How long is this one? Let's just see what we got here. I think I've got it. We'll pull it up here. Give me a moment here. Let's go into. We'll go in and watch that here in a second. Once I finish this thought on Mr. Tucker. But essentially, what he's trying to do is he wants to use this as a platform, his case as a platform, because, see, there are other people that have been affected by the Key West Police Department. There are other victims of Penny Phelps. There are other victims of Colleen Dunn. They're bringing, right now, I haven't been able to confirm it, but I have sources that say Colleen Dunn has been rehired by the Key West District Attorney's Office. Because she was just reinstated back to the Florida bar. So they're stacking the deck again. They're going right back. And Tyrone Tucker is saying he's willing to sacrifice his own personal freedom to try to put this out there. Now, the side effect is, and I guess this is kind of the counter argument to what he's trying to do, is it's questionable whether or not he'll be able to, without having an advisor at the table, which is why the judge, my opinion, that's the real reason why the judge in the first trial wasn't allowing his advisors there, because he doesn't want Tucker to understand how to get the evidence in. Because, see, a lot of what Tucker wants in can get in. He just doesn't know how to do it because he's not an attorney. And there's ways you have to do it. You have to lay the foundation. You have to establish it. That's why at the beginning of the Rush trial, I was going over. I said, these are foundation witnesses, because you can't just bring a photo in. You've got to establish why it should come in. You got to establish how it was taken. You got to make sure that it's relevant to the case and all these different things. And it's not hard to do, but you got to know who to call. You got to know the questions to ask, and you got to know how to do it. And then when you have attorneys over on the other side who are objecting, throwing up motions and things, it makes it difficult for him to achieve that. So give me a moment here. All right, so I'm back here. So we've got it pulled up. I don't know, Eon, if this is the correct one or not, but I found this. We'll take a watch and see if what it reports on. But it says it's about the juror interview. So let's see what they have to say here.
Following this trial, and tonight our coverage continues with the verdict.
Reporter John Cardinelli went to Santa Fe for that ruling.
Around 4 o'clock this afternoon, the jury coming down with a verdict finding Rust Armor Hannah Gutierrez-Reed guilty of involuntary manslaughter, but not guilty of tampering with evidence. After court today, we caught up with the defense, prosecution, and a juror. Here's what they had to say.
You know, given the amount of evidence that they had to consider, 3 hours is a very quick verdict.
Members of the jury on day 10 reaching their verdict based on one single fact.
Too much is just that never did the safety checks, never checked the rounds to pull them out, to look at them, shake them. I mean, if you'd have done that, this wouldn't have happened.
Jury member Alberto Sanchez comparing Gutierrez-Reed's lack of checking ammunition similar to how he has to be careful with what he does as a CDL driver.
I have to check in my vehicle, make sure I'm not going to slam into people or do something like that. And that was her job to check those rounds, those firearms.
After court, ABC News catching up with prosecutor Carrie Morrissey, who said it's hard to say she's pleased with the verdict.
Nothing's ever going to bring Helena back to her family. It was a hard-fought case, and we're glad that it's over, and we hope that it brings some closure to the Hutchins family.
Gutierrez-Reed's attorney, Jason Bowles, saying he respects the jury's decision, but he's disappointed.
My sense was the evidence wasn't sufficient to convict, and it was a lot of guesswork and a lot of speculation, but again, the jury rendered its verdict, and we'll be appealing that.
Sentencing for Gutierrez-Reed is expected to happen in April. Our legal expert says she can face up to 18 months in prison. I'm John Cardinelli reporting, KOAT Action 7 News.
Well, interesting. But that was exactly what my take was, because I believe that jury was going to convict for that exact reason. Now, in the closing argument, see, when the case got finally argued, I understood for a minute what the defense was trying to get at. And he also said they were all on board, didn't even consider. Well, the thing is this, Alec Baldwin comes into play. See, my opinion is this. This was an accident. Okay. So the reason why this case is different than the Crumleys, and that's why I felt that it wasn't going to matter, because the defense tried to argue that Alec Baldwin's intentional act. See, the key is understanding that, and again, we're going to get into looking at that case, and you guys will understand better why the defense was making that argument. Because there's the case, and again, I can't remember the case off the top of my head, but there's a case. So it's the pinnacle case when it comes to involuntary manslaughter, and it basically states that that if there's an intentional act or an intervening cause, which can be an intentional act, it takes away the causation, or is no longer makes whatever she did, the failure to check the bullets and all that stuff, that's no longer the proximate cause of the shooting, because it got in the way, because an intentional act disconnects that, because you can't foresee an intentional act. So in other words, an accident, Alec Baldwin picks the gun up, he's pulling it out, and it's boom. What they basically, I don't agree with the remand. It's an 18-month sentence. I think that was just to placate the media and to make her look tough, because she knew eyes were on this case. I thought that was horrible. I really did, because it's a situation where, she was going to go to jail, right? But she would have gone to jail from sentencing. This is not a life sentence. She's not going to run from 18 months, because she might not even get 18 full months. I mean, the defense has a long range of what they could have argued. And I really agree that, I agree with you, Dolores. I think it was a very, very, distasteful thing that the judge did there. I was not impressed at all with that. It was just, but that's what, unfortunately that judge, I kind of had the sense that judge was playing to the cameras anyways, because she was doing a lot of things throughout the trial that I just felt that's just kind of the vibe I got from her. But yeah, that was, so, with that, let's jump into what I was going to play anyways. Let me find all right, here it is. I got to go backwards. Here we go. No. Give me a moment here. We're gonna. There it is. Okay. So here we go. Let me share this tab instead. So here we are. We're gonna watch this clip, because he really gets into the foreseeability factor, which is a bigger deal in Crumbley, less of a big deal here, and the reason being is because in Crumbley you have an actual definable intentional act. You have a mass shooting, right? That's an intentional act that absolutely, under every other sense of the law, should absolutely be an intervening cause. But that's why they took this to the appeal. That's why this took 3 years to go to trial. Michigan appeal court said, nope, and again, this is the part that everybody's got to understand, which is so egregious. In fact, I was explaining this to my wife tonight over dinner when we were talking about this, because I'm going to have her come on and talk about some things. One of the big issues that's present in the Crumbley case is they claim that the reason why the intentional act is not an intervening cause is because they should have been able to understand that intentional act was going to occur because they were aware of the mental illness suffering Ethan Crumbley. But the problem that sits with the state and will always sit with the state and will always be present with the state and will never go away, in my opinion, in this case, is the fact that the state went to Ethan Crumbley's sentencing hearing and argued he didn't have mental defect. That is the only reason why he was given life without parole, because it is the Supreme Court of the United States said if a juvenile has mental illness, they cannot be given life without parole. The same prosecutor sitting in that courtroom right now went into that sentencing hearing and argued that there was no mental defect, that there was no mental illness, and that Ethan Crumbley is the most evil, diabolical, scheming criminal to ever commit a school shooting. And that therefore he was fooling everyone. And the sole reason why he should never be granted the opportunity to go before a parole board is because he has the ability to trick the parole board. Well, if he has the ability to trick a parole board, if he has the ability to trick trained professionals, are you telling me you don't think he couldn't have tricked his parents? That his parents wouldn't have been fooled as well? Because I think it's hard pressed for any parent to believe you're raising a mass shooter until it happens. So that is the thing that gets me about this case. That's why this case is so wrong, the Crumbley case. But anyways, that's that's my issue with it. But listening to this here, I'm with you, Dolores. I think that there was, although I thought I heard argued in the defense's closing arguments that they said that they agreed. It was almost stipulated that there was no evidence that she brought those or was aware any live rounds were on the set. So I was a bit confused because I felt like they had the box, they had the text messages showing that her dad sent her a box that had it that had come from another movie set. But I think the allegations is, or what the defense said in that instance, which might have been a point of confusion for us all, is, and this is what the defense was arguing. They did the lady, I can't remember her name, but the lady in there, Sarah, that was her name. Sarah went on that set and threw away boxes and ammunition. So what the defense was saying is they will never know for certain what came from what. And if there were other boxes that came from PDQ that were thrown out prior to the police doing their searches, that could have been the source of that live ammunition. And what the state's saying, and to me, what is just clear, and this is why I feel like the defense didn't have a strong case here, is regardless of that, there are set protocols that she was to follow that were to ensure that no possibility of live ammunition would ever get in. And she didn't follow those simple protocols. And by not doing that, she understood that should an accidental discharge occur, obviously it could occur and someone could die. The only way you get away from that argument is if you believe, and that's why they were showing that Alec Baldwin, 2 days before, intentionally fired a gun. So what they had to do is they had to prove Alec Baldwin intentionally fired that gun, committing an intentional act, thereby breaking the causal link. And that's what the defense was arguing. And he was saying that video showing Alec Baldwin was doing that demonstrates that this wasn't just a crossbody pull and an accidental discharge. That's why the defense was on top of all those experts and said, does the trigger have to be pulled? So what they were basically saying was if it can't be accidentally discharged and he had to willfully pull that trigger, it means just like he did in that video, Alec Baldwin was just being an asshole, and he does a crossbody pull and decides I'm going to fire a blank inside this church, which is reckless, which is dangerous, which is why Alec Baldwin better take a plea bargain. That's what I'd recommend, because he's going to get convicted here, regardless of what Hannah Gutierrez did, because it was still very dangerous for him to do that. That is a concern. I think the defense created a reasonable doubt for me of where the live round came from, but I still think that's the part. This is why these cases are so nuanced, because essentially the live round, right? How the live round gets on there only matters, right? It only matters then if she, essentially, it would only matter that she knew there were live rounds on there if you believe Alec Baldwin intentionally pulled that trigger, right? So and what the defense is saying is that this is why they started out there saying the state must prove beyond a reasonable doubt. So what he's saying is that, and this is true, and perhaps I'm a bit biased in this case, and again, I admitted that from the beginning. I think I was a bit biased, and the jury got a bit biased. And this is the interesting thing. This is why I always try to preach it. You've got to start this analysis, and we're probably all starting it from the wrong end. You start the analysis from a presumption of innocence, and what he's saying is he is not saying Hannah Gutierrez is actually innocent, but he's saying if you apply the presumption of innocence to this case, then you have to look at the Alec Baldwin situation and you have to presume innocence. The state must prove beyond a reasonable doubt that Alec Baldwin intentionally pulled that trigger or did not intentionally pull that trigger, that it was an accident. And what he was saying is that if it was an intentional act, if you have belief, that if you have doubts as to whether or not Alec Baldwin intentionally went into that set and pulled that trigger, right, then you cannot convict her of, and you think it might have possibly been an intentional act. That separates the issue of her saying she didn't follow safety protocols, because what he's saying is that because it was an intentional act, she would have never foresaw, and you cannot foresee, and foreseeability ends when somebody does an intentional act. So when Alec Baldwin intentionally decides, I'm going to take a prop gun, I'm going to take a gun on set, and I'm going to fire it against all protocols, and I'm going to intentionally do that, that is not something that she is required to foresee. And that's why he gives the example of the nurse and the Tylenol and all of that stuff. But in the event that and what he was basically saying is that the state had to, and this is why Alec Baldwin's attorneys were closely watching, because in order to prove Hannah Gutierrez, they kind of boxed the state into a corner. In order to prove Hannah Gutierrez is guilty, they would have to I don't think I'm being seen. I just realized, oh, wait a minute. I don't know what happened here. Okay, I'm back. I don't know what just happened, guys. I apologize. Yeah, I just noticed because I have my little monitor up where I can monitor my stream, and I saw I went black. So I was like, what is happening there? Do you think Hannah will get the maximum because the judge said, oh, no, she's getting the max? I think this judge has already telegraphed that. I think she gets 18 months. Like this judge already said, a life was lost, and that was her thought process in locking her up. There's no way in the world that this judge is going to give her anything less than 18 months. She's already decided that. She's decided that a life was lost, and 18 months is what's on tap, and that's what she's going to do. 110%, absolutely. And that's a shame because, I mean, I think okay, in order to prove Hannah Gutierrez guilty, they would have, yeah. So essentially, in order to prove Hannah Gutierrez guilty, they have to. What I was saying was essentially is they will have they had to prove that Alec Baldwin that it was an accident. In other words, that it was that it was an accident and it wasn't an intentional act. Yeah, Alec Baldwin is out on bail, and yes, he does. He faces 18 months as well. So it kind of boxed the state into a corner because just kind of like with the Crumbley case, once they go and put forth evidence and put forth the theory, they can't. There's a problem with when the same prosecutor's prosecuting both cases because you can't go say one thing happened and then go back in another case and say another thing happened because you have to be. There is a requirement of honesty for any officer of the court. It's what my issue is with the Crumbley prosecutors. They're being dishonest. They go to one hearing and they say one thing, and they go to another trial and say another, and they say, "Oh, we're not doing that because you can have both happening at the same time." I don't believe you can. But yes, I believe the lawyer's just telegraphing the fact that the judge sent her to the jail and remanded her, and the comment she made that we have a death and made that comment. I absolutely believe she's going to sentence her to the max. Absolutely to the max. That's just my feeling. I really do. Yep, 16 years. Well, see, it's all in the state. It's all in the state. And remember, the Crumbleys are multiple counts. So it may not be 15 years because it depends on how they on the sentencing guidelines and whether or not they run concurrent or not. I heard that they may run them concurrent. If they run them concurrent, the Crumbleys may get less than that. I think potentially, there's a potential there. But yes, I know it seems unfair, but it's just a difference in states and a difference in the statute and a different how like I said, West Virginia, involuntary manslaughter is a misdemeanor, 1 year, no more than 1 year in jail, not even prison, jail. So every state deals with it differently. Every state has their own way of dealing with it, and it's like I guess if you decide to ever move and go to a different state, probably would behoove you to look up the laws of your state that you're going to be moving to, because it can be it can be quite surprising sometimes when you see what the laws are of a particular state over another state. All right, so let me play this here. And the reason why we're listening to this is because it's just going to be a small clip here of him describing foreseeability. And I just think he really does a good job of explaining it here. So give me one moment. Let me.
Situation where at the end they had somebody they could all blame. It didn't work out with OSHA because OSHA didn't buy it. OSHA said it was the higher ups. So here we are in a criminal court where the government tries to pin all of it on Ms. Gutierrez-Reed. And it's just not the truth. It's absolutely right. We do want the truth. We want the truth and all the facts that were found by OSHA to be considered. We wanted all of the facts that you don't have in this courtroom to be considered because that's the only fair way to do it, to resolve all reasonable doubt and to rule it out. If you don't have all the evidence, you can't rule out all of that reasonable doubt. I want to talk about foreseeability, and I want to play this for you.
And this is the part we're listening for. And I agree, Jan, they were blaming everybody. But remember, their idea was to raise doubt.
Now, you probably remember that. That was the scene where Mr. Baldwin runs up the hill and cut is yelled. And right after cut is yelled, he shoots. That's, I submit, reasonable doubt, and I'll tell you why. Because Mr. Baldwin went off script. He chose to fire after cut was called, and you're going to see where he does later do the same thing in this tragic shooting. Mamie Mitchell told you on the stand, the script supervisor, that it was not in the script for Mr. Baldwin to point the weapon. It was not in the script for him to point the weapon. And we have to be very careful with facts when we're considering a criminal case and the beyond the reasonable doubt standard. That's extremely important, because Ms. Gutierrez-Reed, nor anybody else, knew that Mr. Baldwin in that moment was going to point the weapon right at Helena and Hutchins and Mr. Souza and do what he did. That is the concept of foreseeability. Now, Ms. Morrissey gave you an example of, if I hand somebody a firearm and it's loaded, and then they go and do something with it, and it hurts somebody. But here, what we had, she did not know Mr. Baldwin was going to do what he did. No one, first of all, called her back into the church that he was using the gun at that time. She had given it to Halls to sit in the church. Mr. Halls then gave it to Mr. Baldwin, and that is the conclusion of the lead investigator. That was what Baldwin said, and that is what Ms. Gutierrez-Reed said. So Halls hands it to him. No one calls her back in to let her know Baldwin is doing that blocking scene. She doesn't know that's happening.
Okay, and what he's explaining here, so you guys can understand here, he's explaining the fact that there is a requirement. See, she's now, even though she loaded the gun, when those acts, when they're what you call intervening causes. So when Halls intervenes, takes the weapon, gives it to Baldwin, that was outside of the realm of expectation. Those were intentional acts, thereby eliminating any effect she had by loading the gun. Now, you have to believe, number one, now the problem would be, of course, right, is the issue I have with that is, and then we're going to listen and he'll finish it. What he's going to finish and say is then Baldwin intentionally fires, does the crossbody pull, and fires the gun intentionally. The intentional act, technically speaking, if the jury believes it was an intentional act of Alec Baldwin, an intentional act of Hall, they intervene and they do that. But the problem being here is that if it was an accidental situation, and she should have been, number one, the state kind of lampoons this because they say, well, she should have never left. She should have been there. It was protocol that she was when they thought it was protocol that or they point out that it was protocol that the armorer must be on set at all times when a gun is on set. And the fact that it wasn't, the fact that she was out there in the at her cart doing things she should have been doing 3 hours before, that was against protocol. So therefore, again, setting up the potential that someone could pick up this gun and do something accidental. So I take umbrage with the fact that the defense here is saying that this was all intentional. I don't believe it was. I believe it was just the idea. It's like you leave candy on the table, parent leaves candy on the table, and you leave a couple of kids out there, right? And then the kids eat the candy. Those aren't intentional. That's just what's going to happen when there's no supervision of people that need supervision. And in this case, it was the armorer's job to supervise. So if a kid eats candy, breaks their tooth, whose fault is it? Well, it's the person that they shouldn't have been eating the candy, right? They should have been checking the candy. They should have made sure that the kids weren't doing that. And in this case, that's why the defense lost. That's why I said, he's saying, though, is it beyond a reasonable doubt? That you have to prove beyond a reasonable doubt that there was no chance that these were intentional acts. And if you believe they possibly were, you believe Alec Baldwin intentionally pulls that trigger, then that completely negates any of the negligence on Hannah Gutierrez's part, because it's the foreseeability. And he'll explain that here in a little more detail. It's the foreseeability. And that's the part that the Jennifer Crumbley jury missed. They said, well, she mishandled the gun. She left it out for him. But what they forgot, and they looked at it as it was two separate things. It was either did she not secure the weapon, or was it foreseeable? Should she have allowed him to go back in? And that's why the jury foreman said, well, for us, we just decided to completely forget about the foreseeability thing. We thought that was weak, so we didn't even consider that. Well, that's a concern, because the instruction actually was that regardless of whether it was viewing it as she should have stopped him from going into class and brought him home, or it was you should have secured the weapon. Both of those required that in order for those to be viewed as proximate causes of the deaths of the children in the school, that it had to have been reasonably foreseeable that he was going to do a mass shooting. And if you don't believe it was reasonably foreseeable, then the mere fact that she left that gun in her car doesn't rise to the level of negligence, of gross negligence. That's how you get to gross negligence. The same here for Hannah Gutierrez. In order for it to rise to the level of gross negligence, it has to be foreseeable that that whatever act occurred or whatever circumstances occurred, but the moment that somebody comes in and does an intentional act, i.e. Alec Baldwin points a gun intentionally at somebody and pulls the trigger, now you're dealing with manslaughter, not involuntary manslaughter. Now you're not dealing with negligence. You're dealing with a intentional act. And that's what the defense's argument was. It was that Alec Baldwin interrupted the causal link here, and that made it so that Hannah Gutierrez was no longer, her negligence was no longer the proximate cause of this shooting. That it was that Alec Baldwin interrupts that and intentionally does something that she could never have foresaw, and that was their argument. They didn't really make it clearly in opening, because I didn't even understand it until the closing. And then they didn't really pound it home that that's what they were trying to allege. And that's really, really super important, because, Alex's attorney is going to say he never knew right. And he's going to say that he was relying on what he thought was someone whose professional duty was to ensure that that wasn't there. So they're going to say, but the problem is that it is known protocol that you don't, again, how many jurors are you going to get around to say it's ever okay to take a firearm, whether you believe it's loaded or not, point it in the direction of a human being and pull the trigger? I'm not by any means a gun enthusiast. I don't really do much with guns. Okay. But I know from having neighbors and people around me and stuff, that was the thing I learned at a very young age. You never, not even a play gun, you don't ever do that. My dad instilled that in me. And like I said, guns aren't my thing. So that's something that I think is going to fall on deaf ears of a jury, to suggest that what he did in that room, in a room filled with people, a small enclosed area, and he's pointing a gun, and he's, again, you're going to see in the Alec Baldwin case, you're going to have the Jennifer Crumbley effect. The Jennifer Crumbley effect is she was not likable. Alec Baldwin is not going to come across as likable when they view, because the state's going to go in overdrive, showing what a prima donna he was, showing what a jerk he was to everybody on the set. So, and showing then that he goes in there and he just felt like he could override everybody. So what they're going to use that to negate the idea that now Alec Baldwin, who's a jerk, who's demanding things go fast, who doesn't care about safety calls, and then he's going to say, "Oh, now you're going to say it's the fault of this person." Alec, it was your fault in the first place, because you were demanding everything go your way, and you wanted to go faster, and you wanted to get things done, and you wanted to be able to stay in character and, have it run your way, and you felt like you're on this semi-amateur set. You're the big dog on the set. So they're going to say, no, you don't get to do that. You don't get to now claim, now you're going to fall behind the people that you didn't even think were competent enough to stand there with you, or be there with you, and you didn't even respect them enough to slow down or do safety briefings or any of that stuff. So they're going to hit him. They're going to hit him. Well, I think the issue with that, Eon, is going to be a matter of, He might. It just depends on how much. And again, I haven't seen the pretrial. I assume maybe they'll cover that, but one of the factors will be how much of what I just talked about comes in if he doesn't take the stand. See, if he gets on the stand and takes the stand, it may open up that in rebuttal, they can get in things that his defense doesn't want. In other words, there's videos, there's stuff that they can bring in. Like if he goes on and says, no, I was fully reliant on Hannah Gutierrez and I trusted her. Well, then they're going to bring tapes in showing him disrespecting Hannah Gutierrez, showing him running over Hannah Gutierrez, showing him running over the authorities on the set, showing that that he believed he was above all of that. So that's the danger of putting him on the stand. Now, some of it may already come in, but his attorneys are going to fight to keep a lot of that out because they know how it's going to look. So that will be the thing that would keep him off the stand in this case. Now, his attorneys may feel that he doesn't need to take the stand because remember, all of these people did the number one no that you should never do if you're being investigated for anything in your life, innocent or not. And that is they talk to the police. And they talk to the police without attorneys. Then they talk to the police with attorneys. In fact, this gentleman was there with Hannah Gutierrez, and I don't even know what he was doing in that room because he just let them run roughshod over her and ended up getting her indicted. I mean, it was crazy. But bottom line is, if these people would have kept their mouth shut, if you noticed, a lot of Hannah Gutierrez, a lot of this case was based on the statements she gave and the police going backwards then to try to make their case out of the statements that she gave. And that was, a huge thing here. I mean, everyone on that set, let's see here. So everyone on that set are apart from the camera crew. Sarah Giddy, I know she's more, I mean, well, that's what I think. That's why he was trying to make the case that they wanted to go after Hannah Gutierrez and that there was a conspiracy to do that. Because I think the idea was put it at Hannah Gutierrez's feet. She has no career. She's the lowest of them all, and put it all on her, and everybody else avoids any type of accountability. Of course, Alec Baldwin, was indicted, then it was dismissed, and now he's been indicted again. And I think this prosecutor is going to go after him, and we're going to see Alec Baldwin better be prepared to serve 18 months because I think he's going to serve 18 months because if he gets convicted, and he's going to. And again, I'm going to enter the trial as open-minded as I possibly can because it is important that we apply the presumption of innocence. Even if we think they're guilty, the state still has to prove it. And perhaps I wasn't as fair as I should be in this case. I know I have to reflect back on it. It was also a tough case for me for other reasons too. I kind of just threw all that out and said, you know what, I'm going with my emotions and feelings because I was already emotional anyways. So
the medic said she did not hear anybody call that out, first team over the channel. So that's not getting put out. So Baldwin's doing another audible like he did on this video that you just saw. He's going off script. That defeats any idea that was foreseeable to Miss Gutierrez-Reed. If she doesn't know what's happening, she can't foresee it. That's a big part of the instruction. The other part I want to talk about foreseeability and where this matters is live rounds. Now, live rounds in this type of situation has not happened in Hollywood. In the 100 years of Hollywood, this has not happened in a situation like we saw in this case. No one on that set foresaw, knew, or thought that live rounds were going to be on that set. No one. You did not hear one witness in this case. Even Miss Morrissey said there was no evidence that Hannah knew about live rounds coming on or this was done. There's no evidence of that. Nobody thought live rounds were going to be on set. Mr. Souza told the doctors he couldn't believe it. He argued with them because it was inconceivable that live rounds would appear. Because of that, when you read the jury instructions, there's a concept in the involuntary manslaughter of an element of willful disregard of the rights of another. That word willful, and I'm going to go over it soon, means purposeful. that you willfully do something, you purposefully do something. What's impossible for the government to prove in this case.
Can we approach?
And ladies and gentlemen, I'm going to talk about willful more in a moment when we get there, but it cannot be willful if Hannah does not know there's live rounds, and nobody did. So she did not do something willfully, knowing that Baldwin could foreseeably hurt somebody with this firearm, because she didn't know it was live. And let me give you an example. It's akin to a nurse, let's say in a hospital, who the pharmacy mislabels a drug. And let's say it comes to her and somebody's ordered it be administered to a patient. She then administers it not knowing that it's a fatal drug of some other type. The pharmacy's mislabeled it. The patient passes. It's the same situation as we have here, where the government would be saying the nurse committed involuntary manslaughter. No, that's not true, because she did not know what happened. It's like a long time ago when the Tylenol capsules were laced with cyanide, way back in the 80s or somewhere around there. There was no prosecution of the pharmacies that didn't know about this, that were tainted by it. It's the same type of situation we have here with the nurse. Miss Gutierrez-Reed did not know there were live rounds, and she was entitled to rely on production buying dummies and the boxes labeled dummies. She's entitled to rely on that. And that reliance is reasonable. So she cannot foresee a live round. Now, I want to talk next about Ms. Gutierrez-Reed's statements to law enforcement. You saw her first statement.
So there, that's the section I wanted to listen to. And the thing I would say that I take issue with him there is that then why would there be the protocols in effect that she needs to check each bullet and show the first director what's going on, show the first director the rounds and all the different things. The idea is to make sure there isn't a live round in there. There is no ability for an accident. And if you're not doing that and one gets in, then you are responsible. That is your negligence. Your negligence not to follow it. And I understand he probably doesn't like that. That's why that juror said all of the defense stuff doesn't really matter. And in my reading, again, I don't have the jury instructions in front of me. I haven't been able to read them. I haven't been able to find them. And perhaps I'll find them and be able to go through them. And perhaps I'm not going to say this gentleman here. Obviously, he's attorney. He has the jury instructions. Perhaps he's correct that maybe the way the manslaughter law reads or involuntary manslaughter reads is that it wasn't something of consideration. But I don't understand then why the state went through all the pains to go over the ways that you can identify live rounds and the fact that she failed to do that, because the reason why they did is because it doesn't require her to have to know live rounds were on the set. The point is she could have prevented the death by doing her job, and she failed to do her job. And that is true. Let me see here. Let's see if I can find that complete jury. I'm very curious now to hear this. Let's see if I can find Ruster speaks out. Ruster interview, full interview. Let's see here. Not the 2-minute deluxe. We want the whole enchilada here. Let's see what we can find. Yeah, I can't find it. I'll have to continue looking for it because I'd like to hear everything that the juror said. Um, and like I said, I agree with that. Why take the job? I mean, she, in my opinion, and I've dealt in the capacity of jobs in capacity of where I've been over and oversaw things, and I've had employees for myself work for me that didn't understand why we did things or didn't understand why protocols followed, and they just decided they were going to do what they wanted to do, and that was kind of the feeling I got about Hannah Gutierrez, that she didn't really feel like it mattered. And it matters. Like I've always told everyone, it doesn't matter till it matters, right? It's just like in one particular case, I took over a particular operation and I'm reading through the files and going in and digging in to try to figure out. And I found a file that was explaining how some cash drawers had gotten broken into by cleaning staff at the building that we were operating, right? And I'm reading through here, and I see that the entire, like the cashier, the the manager of the operation, everybody's written up, right? And the reason why they were written up is because they weren't following the basic protocols of cash handling. And when they when they discovered that these cash boxes had been broken into by the cleaners, they weren't able to account for how much money was in there because they didn't do the appropriate receipt tags. So, although these people didn't steal money, they ended up getting in trouble and ended up getting write-ups in their files. The manager got censured, and that was all because they didn't follow it. Now, look, had nobody broke into a cash box, nobody would have ever known. We're not saying that they caused the break-in of the cash box, but they certainly caused the company to be not able to account for all the money that was lost because they couldn't specifically say with verification and certainty the exact amount that was taken. So as a result, guess what? The cleaning company got away with they couldn't go after the cleaning company because they couldn't say for certain that there was money in the cash box to begin with. So again, it's one of these things where you follow the procedures, and your negligence, when you're negligent in something, if you're not following procedures and then something happens, now you're going to get held accountable. Thank you, Dolores. I appreciate that. So to me, that is something that, in this case here with her, that's why I believe firmly. I think the jury got it right. I just don't, and maybe I'm a little biased because I was seeing some people that have worked for me in the past that I've dealt with, and I'm like, this is exactly what I would say that, I'm telling people, hey, this is what we're fighting against. This is why we follow it. This is the one moment that something goes wrong. And this is why you follow procedure, because it protects yourself from having accountability when something happens and everybody's looking in, and then everybody gets held accountable, and it affects things in ways you never even know, understand, or realize. And you don't realize it until something bad happens. So that is what we wanted to watch on that. Now, let's get into, give me a moment here. We're going to switch gears. And all right, I'm back. So we're going to switch now to the Crumbley jury instructions. So let's take a look at these. Share this tab instead. Let me get in here and remove. All right. So let's blow these up so everybody can see. So these are the instructions of the law, right? As this is what the Crumbley jury had, right? So the reason why I want to go through this is because this was Jennifer Crumbley's jury instructions. This helps to understand. We didn't have these at the beginning of her trial. I only had like I think it was like a working copy, but these are going to be similar. These are going to be exactly what this jury is going to get. So as you're watching, you can be aware of what you're looking for. And again, I hope her defense is really zoned in on helping the jury to understand how to deliberate on this case. And they will see why it's a difficult, it is a difficult case. It's a very difficult case, in terms of, understanding how to apply the law, because it's not simple. It's not like, oh, we've got, we're trying to assess an intentional act here. No, it's a matter of, having to really get into the nuance of the law here. So, the first thing here, we're not going to go through all of it, because some of it is just, perfunctory instructions, like the burden of proof, presumption of innocence. That's not really what we're looking for. What we want to get into, is, and we're going to go down here, witness credibility, how to assess the witnesses, multiple defendants, time, place, venue. Let's go here. Defendant's statements as evidence. Facts that can be proved circumstantial. That's not necessarily. Now, here's another one. This is what I think is comical. And you tell me if I know there was discussion in the comments comment section today of or the chat today. The flight. This is the most ridiculous part of this case. This is, to me, that just shows how disingenuous this prosecution is. Flight, concealment, escape, or attempted escape. This is what they're trying to say. Them hiding out in the art gallery. There has been some evidence that the defendant ran away and tried to hide after she was accused of the crimes. 2, this evidence does not prove guilt. A person may run or hide for innocent reasons, such as panic, mistake, or fear. However, a person may also run or hide because of a consciousness of guilt. Boy, the state forgets about that first line, don't they? They forget about that. So, again, why Shannon Smith wasn't up here with this up on her board, and on there and saying, number 2, first of all, a person may run or hide for innocent reasons, such as panic, mistake, or fear. Ms. Crumbley was panicking because the press was at her house. And they should have, at least in their case in chief, put somebody on the stand, whoever was that, some of the people she was texting, to say, yeah, her neighbor, he was telling her, the press is at your house. They should have been on there, on the stand, and the defense should have been making that an issue. I hope her defense attorney this time does that, or for James does that, because obviously, the community was up in arms over the fact that their son just shot up a school. 3, you must decide whether the evidence is true, and if true, whether it shows the defendant had a guilty state of mind. Of course, it doesn't mean they had a guilty state of mind. Who the hell runs from a scene and literally is like a couple miles from the courthouse, hiding out in an art gallery? Where exactly are they fleeing to? I mean, these people are not millionaires. Where are they going? They couldn't sell it's not like they sold their house for cash. It took them months to sell their house after they got arrested. They were going nowhere. They were not rich. They didn't have. They had access to a couple of $1,000s, and all they were trying to do was secure a lawyer and then make sure that between the time they had to report to court and appear in court and that time, that they wanted to stay safe, because there were people out there that had the pitchforks ready to go to get them. This, to me, is like, it shows how unreasonable and ridiculous the state's case is, and it just really gets in my craw. I want to see a not guilty so bad, because that Keist, both of them. I can't remember the lady prosecutor, but both of them are so. They just piss me off so much, because they're not genuine, and they're not arguing a genuine case, and that really bothers me. Let's see here. So let's get in here. Jennifer Crumbley defense was overwhelmed. Oh, something was wrong. I don't know, because that attorney, like, believe it or not, I researched that attorney, because when she made the statements about unaliving herself in front of the jury, I'm thinking, what the heck? I mean, listen, Jennifer Crumbley paid her $75,000 for that defense. $75,000. She should get a refund back on for some of the stuff that happened, I think, in my opinion. I mean, it was just something was wrong. Although like I said, I know she had some medical problems. I just felt like she wasn't prepared. I felt like the moment got bigger. I felt like she ended up in trial, and for her to not be prepared, that was really terrible when you're paid a large amount of money like she was. All right, so let's get through this here. All right, involuntary manslaughter. So here we go. We're going to get into some of the stuff. In count one, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Madison Baldwin. That is, that Madison Baldwin died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by her minor child. This is where everything got confusing. And I understand why it would get confusing, because it's like, okay, first, in order to prove, they forgot the fact that you got to prove both, right? So they didn't understand this. So they said, okay, first is that died as a result of storing a firearm and its ammunition as to allow access. No question, that happened here. This is the part that was a question. This is the part that Shannon Smith needed to make clear to that jury. Listen, we concede that that might be the case, but you've got to go, like, let me walk you through deliberations. Question one, find this. You stop there. If you say no there, we stop. We don't even go further. But if you say yes here. Second, in doing the act that caused Madison Baldwin's death, the defendant acted in a grossly negligent manner. The whole issue is, what is grossly negligent? What is a grossly negligent manner? Okay? That's an issue. And that is what was at hand. Now, notice that's present. And the reason why I'm showing you is because there were two theories, right? There's the theory here that died as a result of the storing of in access to firearms. So remember, James Crumbley is going to have the same thing, right? But just because 2 is true does not make her guilty or him guilty of involuntary manslaughter. 3 has to be true. And we're going to talk about 3 because 3 is where everything relied upon. Okay. Now, this is this is called a non-standard instruction. Okay. And as I explained earlier in my instructions, the prosecutor, and this is what they asked about and were confused about, asserts 2 different theories to support the charges of involuntary manslaughter. First, the prosecutor claims that the defendant committed involuntary manslaughter because she failed to perform a legal duty. Now, that's where we're talking about the legal duty being to have removed him from the school, taken him home, and gotten him help for his mental health, right? In the alternative, the prosecutor claims, and the legal duty was a legal duty to protect the children of that school. She had a legal duty to protect children from that school from her mentally deranged son. But it requires her to know that he's mentally deranged. Also, the juror in the Jennifer Crumbley case said she had the gun last, but in the 911 call, James. Yes, exactly. I know that was another thing. That was crazy to me. I mean, that's why I said that they got confused, and somebody back there. I know how it works. I've been on a jury before. Okay, I know exactly what happened back there. Somebody made this point that she was the last one with the gun. They were fighting. They were going back and forth. There were some holdouts. And then somebody decided to be a judge and interpret the law. They interpreted it incorrectly, and they said she was the last with the gun. And it's why they were asking the questions that they were. And they basically said, this is what the lady said, they threw this one out. This one, she said, they didn't really think they had a case for. And the alternative, the prosecutor claims that the defendant committed involuntary manslaughter because she was grossly negligent. Those theories are 2 different ways to prove the same crime. Either or both of these theories, if proven, are sufficient to establish the crime of involuntary manslaughter. The thing is that the legal duty and the grossly negligent both required her to have foresaw that her son was going to do this. They believed that the legal duty was the thing that attached the foreseeability to it. They believe that grossly negligent dealt with the storing of the firearms, and that the mere storage of the firearms in a way that her child could get hold of it was enough to convict her and was enough to say she was grossly negligent. That is incorrect, and we're going to show you because it's going to be explained. It is not necessary that you all agree on which theory has been proven, as long as you all agree that the prosecutor has proved at least one of those theories beyond a reasonable doubt. Failure to perform a legal duty. So in count 1, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. And this is why there was confusion, because they saw this as the only one that had the need to deal with his mental health issues. And the text messages from 7 months ago, they didn't believe that had anything to do with the storage of the firearm. That's how they looked at it. That was her defense attorney's job to make sure they understood those two things were intertwined, and that you don't have that both legal duty and gross negligence both required her to foresee that her son, and both required that they find that her son was mentally incapacitated to the degree that he was going, and that they were aware that he was mentally incapacitated to a degree that he was going to commit a school shooting. Let's see here. What do we got going on? And the defense in this case are not cross-examining anyone who testifies about what Ethan did, which I like. The state seems to have been saying that the dad, upon hearing the shooting, drove home to check the gun, suggesting it was foreseeable. Well, see, yeah, but that's not true, because he drove home after the shooting, meaning that after the shooting, he did it afterwards. That's the state playing with the facts, and again, what they're going to do, just like the Tucker case when they put on the Paula information and went and argued it how they argued it. It's her attorney's job to go argue at closing arguments and say, no, that's not what we're talking about here. But his attorney seems to be a little bit more together than Jennifer Crumbley's. First, that the defendant had a legal duty to Madison Baldwin. The legal duty charged here is one imposed by the law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent the minor child from intentionally harming others, or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. Now, here's the other conflicting issue. They charged him as an adult. So therefore, in the eyes of the state, they viewed him as an adult. So therefore, he was no longer a minor child in the eyes of the state because of the crime and the severity of the crime and the fact that he was such a diabolical criminal. In my opinion, that should have been an affirmative defense that they should have been allowed to put up. But the judge obviously said they were not allowed to bring that up. But to me, this is a conflict. The state cannot have it both ways. And they should have been allowed to argue that. The judge said no. This duty arises when both of the following are true. Okay, so the parent knows or has a reason to know that they have the ability to control their minor child, and B, the parent knows of the necessity and opportunity for exercising such control. Second, that the defendant knew of the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. And fourth, that the death of Madison Baldwin was directly caused by the defendant's failure to perform this duty. That is, that Madison Baldwin died as a result of the defendant's failure to exercise reasonable care to control her minor child so as to prevent the minor child from intentionally harming others, or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others, when the defendant knew that she had the ability to control her minor child and knew of the necessity and opportunity to do so. Okay, obviously, I think as we've discussed this, it should become readily apparent the absolute conflict that exists here with a state that's arguing that, in this case, they're arguing that she should have known that her son was mentally deranged, that due to 7 months before and 4 or 5 text messages, that she should have known that he was struggling and having problems, and essentially that she had a right, that she should have known that when she saw that paper at school, and even though a trained professional said this paper to me represented a suicide attempt, they're saying no, they should have seen that looked like the gun, although if it was his new gun, wouldn't that be the gun he would use if he was going to shoot himself? So I don't necessarily think that would trigger anything to, what the heck was that? That would trigger anything I don't think that would trigger anything in my mind that would say, oh, this person is this child is going to go shoot up a school. I mean, that doesn't make any sense. But that's what they're saying, is that she should have, or he should, when he saw that. But to me, when you look at that paper and then he scribbles over it and he says, and she's talking and consulting with professionals, and they're saying, "Hey, keep him in. It's a mental health crisis. It's not a situation where you're going to go shoot up a school." He never made that threat. He never said that. Yes, he'd written it wrote it in a diary, and that's the problem where the state in this case is so disingenuous, because they use that. They put that diary up before the jury, which is so inflammatory. They don't get it. They're not putting Ethan Crumbley on and say, "Yeah, my parents were aware of this diary." Now, that's a different story. If they were aware of that diary and did nothing about it, we have a different situation. But that is not the evidence that's before the jury. That's not what went before the jury. That's not what's going to go before the jury in James Crumbley's case. So, thereby, this is the weakest deal. This is the weakest link. And the jury said that. That's what they said. The failure to perform a duty. Now, it goes through Tate Mayer. It goes through. So, the legal duty, they dismiss completely. So again, that should be something that should be good for James Crumbley to know that it's very weak. The other jury didn't do it. So now that, again, in order for James Crumbley, that's why I said James Crumbley shouldn't be afraid. His attorney should just have paid attention. Because if he pays attention, then, or if she paid attention, she's going to understand what she needs to do is just be the guide to the jury on how to get them to a not guilty verdict. So he says, act of the defendant must be cause of death. There may be more than one cause of death. It is not enough that the defendant's act made it possible for the death to occur. In order to find that the deaths of Madison Baldwin, Tate Mayer, Hannah St. Juliana, and Justin Schilling were caused by the defendant, you must find beyond a reasonable doubt that the deaths were the natural or necessary result of the defendant's act. You heard evidence that the defendant's son shot Madison Baldwin, Tate Mayer, Hannah St. Juliana, and Justin Schilling. As previously noted, there may be more than one cause of death, and the defendant's acts or inactions need not be the sole cause of harm. In order to find that the death of Madison Baldwin, Tate Mayer, Hannah St. Juliana, and Justin Schilling was caused by the defendant, you must also find beyond a reasonable doubt that her son's act of shooting was reasonably foreseeable. This is the whole crux of it. They're saying that in order to go for either gross negligence, and this is where her attorney failed, she needed to break this down for the jury. Yeah, I do too, Ian. I really do. I think she's going to do a good job here, and I hope so, because what I want to see is a guilty and a not guilty, and see that conflict. That'll slow this thing down from any other parents getting ensnared in this nonsense. But it's here. You must also find beyond a reasonable doubt that her son's act of shooting someone was reasonable foreseeable. That applies to both. Now, here we are, gross negligence. So let's look at gross negligence. Gross negligence means more than carelessness. It means willfully disregarding the results to others that might follow from an act or failure to act. In order to find that the defendant was grossly negligent, you must find each of the following three things beyond a reasonable doubt. And this applies to the storage of the weapon. This applies to the failure to having a legal duty, right? Both of these, this applies. First, that the defendant knew of the danger to another. That is, she knew there was a situation that required her to take ordinary care to avoid injuring another. The question is, what is ordinary care? And this is the problem. The definition here of what ordinary care would be in the circumstances presented to Ms. Crumbley, the appeals court acknowledged, and I'll pull the appeals court up again to show you. This is where the due process issue comes in, because you have a right to notify. She has a right to be notified. In other words, it should have been readily apparent prior to this happening that she understood exactly what would be a violation of this and what would not. And the fact that this was created after the fact, carved out after the fact by the appeals court to justify the district court pushing this forward into a trial is not right. That is a violation of Jennifer Crumbley and James Crumbley's due process rights. And it should have, I'm sure it will be addressed on appeal. I don't know that it could have been addressed on appeal in the form it was, because it's something that normally would have to be addressed after the fact, after you flesh out all the facts and all the evidence and it goes before the jury. But in this case, it should have also, in my opinion, should have been something that was brought up at the time to show why should this be dismissed? Why should this not go forward? Well, I hope so too. And I hope that the jury is not biased in that way, because that would be a shame. Second, that the defendant could have avoided injuring another by using ordinary care. And third, that the defendant failed to use ordinary care to prevent injuring another, when to a reasonable person it must have been apparent that the result was likely to be serious injury. Okay? And again, like I said, the question is, what is ordinary care? And again, it requires, like I said, again, you can see why this jury was very confused, because it's very hard, without having someone explain it to you, that these are all things that essentially, when you go up and you look at the evidence here that says it's got to be reasonably foreseeable, that's present in both sections. And then for gross negligence, which meaning in order for it to rise to the level of gross negligence, it means that she knew that the situation required her to take ordinary care to avoid injuring another. In other words, to prevent him from going forward, because she was aware of his mental illness, she should have taken him to the doctor and provided ordinary care. But the question is, what constitutes that? And that's the danger in this case. That's the danger that is presented. How do we know? So what is the guidebook now that says if X, Y, and Z are present, and you as a parent don't take action, and your child goes out and injures another human being, under this theory of the state of Michigan, you as a parent could be charged as if it results in a death, or it results in injury, severe injury. There's a juror who had been on a criminal case before for manslaughter, and the verdict was not guilty. That's good for the defense. Oh, that's very good for the defense, because that means they understand the law a little bit, and that'll be good, because they need to understand how to apply this, because this is the crux here. So let's share this tab instead here. So this is the Crumbley opinion. Let's see. Let's get this over here. I want to be able to see you guys and monitor and interact with this. So understanding from the perspective now of what the law says, you can now understand, come in here and see how the Supreme Court or the appeals court, the appellate court, again, this entire case was in regards to whether or not the intent, which normally would absolutely have intervened. And when you look at it, here's that sheet, right? This is the sheet. This is the famous sheet right here that everybody's talking about. So let's take a look at it once and for all. Chat, tell me. You look at that. Could you, if you just saw that, nobody's saying shoot. You've got a kid that's a relatively good kid, who's always been a good kid, who's never had a disciplinary problem, and he's writing that on there. Would you think that child was going to shoot up a school? Well, it could. I mean, maybe you could try to make a case, but the question is, but see, the problem with that, Dolores, is in this case, what is the in this case, what is the well, and I hear you there on Eon on that, except for the fact that what about if you're sitting there and they're saying, well, this is a mental crisis. It looks like he wants to kill himself. So and you've got an individual who's a trained professional, a trained counselor, who's saying, he probably shouldn't be alone, and it would probably be good for him to be around friends. So leave him in school. I 100% believe, yes, they should have taken him out of school. I think but here's the thing. I don't think the school should have given him a choice. The school should have said, we have to take him out of school. Like, my kid's school would have done that. I mean, 100%. Any child that wrote that on there, or wrote a gun, or had some sort of firearm, or any type of violent talk. I remember there was like a hit list that went around my son's school, and the kid got brought out. They brought the FBI in. I mean, they went above and beyond, right? So to me, the fact that these school officials didn't do their job and get him out of there is more a school problem. And then when you find out that the school officials were on board with him staying, unless you're going to charge the school officials, charging the parents in this case, who, again, remember, there was nothing leading them to believe. This is not a situation where he's telling them every day, I'm going to shoot up a school, and then they're handing him a gun, and then they're letting him still do it. They're like, well, come on, Ethan, don't do that, and then dad says, let's get your mind off shooting a school, and we're going to go to the shooting range. That's not what's happening here. There was no indication of that. There's no indication of that. For drugs, but not for, well, listen, they search for guns. Hell, man, there's a couple of YouTube videos out there where these people, listen, these guys got on the stand and said, oh yeah, we don't do this. Suddenly they care about the rights of the student and all that stuff, only because they wanted to justify why. Basically, here's what it was. Ethan didn't fit the bill of the student they would search for a gun. And I'll leave it at that. He didn't look the part. That's the only reason why they didn't search him for a gun. He didn't look like somebody that they would have thought would be a threat to anyone. And they made an assumption. And they made a wrong assumption. I'm not sure even if she was guilty of child neglect. I don't feel the man. Look, yeah, it doesn't stick because it wasn't foreseeable that he was going to do this. And that's the point, that there's nothing there to foresee that he was going to do something like that. And the idea, again, like I said, the idea here is that they had an idea in their mind that he was going to do something like this, and they understood clear. Now, see, to me, if I'm arguing this, if I'm the attorney in the case, the greatest evidence as to their mindset is how they acted afterwards. And how they acted afterwards was, my life is over. My son just shot up a school. We're facing criminal charges. We got the world coming after us. They would never have voluntarily put themselves in that position to be facing that stuff. So, and you have to believe that that's exactly what they did here. And that's what that jury said. Well, they don't realize that's what they said. They believe, that jury believes, they convicted her of leaving a gun in a car and leaving access for Ethan Crumbley. And that was it. And they believed that the issue at hand of whether or not he was mentally ill and whether it was foreseeable, that had to do with duty of care. And that's why she said, we just dismissed that completely. It was easier just to go forward and look at the weapon and say, is it possible that if you leave a weapon out for a child to get their hands on? Well, the problem is that wasn't the situation. That would have been true. That would have been a true set of facts if this was Ethan Crumbley accidentally finds his gun and he's with a friend and he picks it up and doesn't realize it's a real gun and pulls the trigger and shoots his friend to death. Yes, that is custom made to dad, mom, whoever is responsible for that gun and leaving that gun out there and not securing it. That is the situation and scenario that puts them in prison. But when Ethan Crumbley picks up that gun and says, oh, I'm going to go do a school shooting with this, it requires them to foresee that they have someone who wants to do a school shooting. And then he goes and does that. Otherwise, Ethan Crumbley's intentional act of deciding to go do a school shooting, it's not foreseeable to them. Thereby, you cannot say that they were negligent or any negligence or any failure to secure the gun or any of that, because they would have never thought that their son was going to go do this. So therefore, they could, if they can't foresee it, it's just, that's why I brought up that clip from that attorney. If you couldn't have thought it was going to happen, if you couldn't have foresaw it, it's not guilty. And that's why what he's saying is that yes, Hannah Gutierrez was negligent. Yes, she wasn't following protocols. she was protecting against an accident. What she couldn't have foresaw was that Alec Baldwin was going to pick that gun up, point it in a room full of people, and pull the trigger intentionally towards those people. And the gun was never supposed to be in Alec Baldwin's hand. Halls gave it to him. Blocking at no point was ever supposed to have a firearm, and she was supposed to be called back into the room when the firearm was going to be pulled. That's what their allegations were. And Alec Baldwin overruled like a prima donna and said, all right, I want the firearm, give it to me. We need to practice blocking. He pulls the firearm out, he points it, and he pulls the trigger. And then she says she could have never foresaw he was going to ever do something like that. And that is probably a legitimate argument if you believe Alec Baldwin intentionally did something like that. But on the same side, if she is following the safety protocols and she is making sure that that gun is not outside of her range, of her view, which it should never have been, and she should have been near that gun at all times, just like that is apparently protocol to the end of time. And she broke that. And by breaking that and going outside and leaving that gun inside there, allowing someone to then hand it to Alec Baldwin, who then goes in and is messing around with it, and it goes off. And Alec Baldwin has not said he intentionally pulled the trigger. He says it was an accident. And she didn't follow safety protocols to ensure that there wasn't a live round, i.e., goes off, somebody gets shot. Now, what she's saying, what the defense was saying, is that maybe somebody set her up, that they put live rounds, not intending that anyone would get killed, but they wanted to get her fired, and they were hoping that a live round would go off and shoot something. It would become clear that a live round went off, and that's what they were saying that Sarah girl was doing. Now, if somebody intentionally introduced live rounds into the dummy rounds, Hannah Gutierrez could not have been guilty. That's what they were saying with that, and that's what they tried to intervene with Sarah's testimony, and that's why there was, listen, was there reasonable doubt? There was potential reasonable doubt. But again, like I said, I think in this case, it was just too much of the fact that she really came across as somebody who just didn't give a shit about her job, and the sympathy meter left there. That boat left there, and she did herself in. I mean, I hate to say it, but I still think the state proved that. Now, what they do with Alec Baldwin now, saying, again, to me, they still have an involuntary manslaughter because they're not charging. If they believe Alec Baldwin intentionally pulls that trigger, they're charging him with manslaughter, not involuntary manslaughter, and he's facing a lot of time in prison. So, I like the bit of that's saying that Alec Baldwin is guilty of an intentional act, and that if that was to be believed, and if that was the case, Alec Baldwin would be facing a lot more time here. And the state said no, it was that wasn't the case. That this was a situation where that firearm wasn't checked. She should have been in the room monitoring that firearm, making sure Halls never picks it up and gives it to her. But of course, this set was not well run at all. So I think the idea at the very beginning was like, do you really want to charge her or charge anyone? Because this whole thing was a disaster. And ultimately that prosecutor got involved. Hannah has another case coming. Really? I didn't know that, Cam Miller. Well, thank you for the information there. So she was carrying a gun in a bar in New Mexico. Wow. Okay. When does that case come up? Do you know? And welcome, Cam. That will be very interesting. I will be very interested to see that one. I mean, potentially, is it a felony that she's charged with in that case? Yeah, I mean, like I said, that's the thing. She's only going to be facing 18 months. It seems like a lot, but okay. Apparently she can get a lot more years for that charge. Okay. So she was just a reckless person. That's what I mean. That's why I said I don't necessarily feel tremendously sad for her because of how she acted and what she did in this case. It's on the docket. They've yet to get a court date. Okay. I got you. All right. So let's give me a moment here. All right, so we're going to switch over here. Let me go into the Justice Watch. Let's see here. All right. So let's listen. We're going to listen to the opening statement of James Crumbley's attorney next and contrast that. We've already kind of gone through, we've seen the jury instructions. Let's contrast with what we hear from her. And do we hear what we want to hear? Oh, it is a felony charge. Okay. Wow. Well, like I said, I think she's going to get the book thrown at her. And I mean, I think there's a lot of anger over the fact that she didn't do her job. Actually, hold on here. All right, let's load this up, and here we go. There I am. There's earlier me right there.
The events of November 30th of 2021 undeniably changed people's lives in ways that most people could never imagine. 4 children lost their lives. Families were destroyed, and a community was terrorized. But this case is not about what happened inside of Oxford High School. This case is about what happened outside of Oxford High School. The prosecution alleges that James Crumbley was aware that his son was a danger to others, and that he failed to protect other people from his son. The prosecution alleges that James Crumbley had knowledge that his son could and would hurt other people, and that he failed to protect those people, that he failed to take steps to protect others. And ladies and gentlemen,
I agree with you 100%, Eon Winstanley.
True. You will hear evidence in this
I
case.
I think that is
what occurred inside of Oxford High School.
I think that's
You
terrible.
will hear the prosecution's version of
And I'll
what
tell you a
James
little bit more about that in a minute.
May have known. You will hear that a gun was purchased on November 26th of 2021 by James Crumbley. You will hear what kind of a gun it was. It was a handgun. You will hear how it was stored. You may hear where it was stored. You will hear whether or not Mr. Crumbley's son knew where that firearm was. Pay attention also to what you don't hear. Pay attention to that you won't hear that James Crumbley knew that his son knew where that firearm was. Ladies and gentlemen, James Crumbley was not aware that his son had access to that firearm. You will hear testimony that access was not allowed in James Crumbley's mind. Ladies and gentlemen, you will not hear that James Crumbley knew what his son was going to do. You will not hear that James Crumbley even suspected that his son was a danger. That math homework that the prosecution is putting up on the screen, you're going to hear about that. You're going to hear about what other people thought about that. People at the school, including James Crumbley. There's going to be probably quite a bit of discussion about that piece of math homework, ladies and gentlemen, and you're going to hear all about it. Ladies and gentlemen, James Crumbley did not know what his son was going to do. He did not know that his son could potentially harm other people. He did not know what his son was planning. He did not purchase that gun with the knowledge that his son may use it against other people. You will not hear that he did that. The prosecution told you that. The prosecution.
I believe it was his ex-wife is who
You're
they're
not going to hear that James Crumbley purchased that gun with the knowledge that his son
referencing
was
there.
going to go harm other people.
Or
But what the
I don't know if it was his
prosecution wants you
ex-wife,
to
but the
believe,
mother of his child.
the
That's going to
part
be
that's not
allegedly
true,
testifying.
is that James Crumbley knew what his son was going to do and knew that he had a duty to protect other people from his son. Ladies and gentlemen, that's not true. He didn't know. You're going to hear about James Crumbley's relationship with his son. There may be other witnesses who testify about that, about how James interacted with his son, including on the day when that math homework was shown. You're going to hear from other people. They're going to tell you, in their own words, what they observed about James Crumbley and his son, about what they observed about his son, about any concerns they may have had. Other people, not just James Crumbley, but other people with additional education, additional training to evaluate situations like this and evaluate individuals. You're going to hear from those people probably. And they're going to tell you in their own words what they thought about the math homework, about Mr. Crumbley's son, about Mr. Crumbley's interactions with his son. Yes, James Crumbley was a DoorDash driver. We all know that. It's been said multiple times. Ladies and gentlemen, being a DoorDash driver doesn't mean that your job is any less important to you or other people than any other job. It doesn't mean that you don't feel that you have a duty to go to work. And ladies and gentlemen, when you're not aware of an immediate, imminent danger, why would you do anything different than what you normally do? You wouldn't, because you don't have any reason to think you need to. So ladies and gentlemen, you're going to hear the evidence. You've heard a lot of questions in the last couple of days from both the prosecution and myself. You probably have an idea where each side lands on these issues. But you're going to hear the evidence. You're going to hear from people other than us. And you're going to be able to hear in their words what they thought about those days from November 26th to November 30th of 2021. And their feelings, what they observed, any concerns that they may or may not have had. The prosecution has asked you repeatedly to follow the law. I'm going to ask you to do the same thing. Please do follow the law. And I'm confident, we are confident, that if you do that, if you follow the law, that you will find James Crumbley not guilty. Thank you.
Thank you, Ms. Newman. Should I give you a little break?
We got a little break.
I'm going to give you a little break so you might have to.
All right, so there you have it. Now, my direct feedback in hearing that is, first of all, she needed to speak, and again, I can say she must not have been watching Jennifer Crumbley. Now, remember, she's actually, I think she's part of the same law firm as that attorney that represents Jennifer Crumbley. But I was hopeful that she was going to follow or get the message that she needed to speak to the jury, because what she really needed to do was help guide the jury in how to interpret the law in this case when they're sitting here listening. And she's speaking in general layman's terms. But when that jury gets back there and they're with that set of instructions that we were just looking at, they need to have a voice in their head telling them how to read them. And she should be speaking to them about those instructions, those anticipated instructions, talking to them what reasonable foreseeable means, talking to them about how to interpret the statute that he's being charged with, talking to them. I don't like the idea that she says, hey, we're going to put up an affirmative defense that he had no idea about whether or not he had access to. The point is, it doesn't matter. Because even if he knew he had access to the weapons, he had to have thought that someone was going to be a school shooter. And that's what she should have been saying. She just said, but listen, we can even go further to say he thought the weapons were secure. Because now what the state's going to do is they're going to go in and try to prove that he did have access. And then the jury's going to think, oh, that means something. It doesn't mean anything, because that's the first prong. The second prong, the most important prong, is that it's got to have been reasonably foreseeable that he believed his son was going to do this. I like the part where she says we're going to put people on the stand. You're going to hear from people about how much he cared about his son and about the relationship that they had. Well, they do have a jury. Yes, they do. And that is helpful. That is helpful. But that's who she should be speaking to. That's what she needs to be talking about. But see, what I'm trying to say is she needed to get the head start to speak to the fact. See, what I don't like about her doing that is she took on a burden of proof. She said, "We're going to prove to you that James Crumbley had no knowledge. I assert to you that remember what that's the wrong way you want the jury thinking about the defense. Whether you have a complete, and again, that's the beef between Franklin Tucker and his attorneys. He understands that. He knows because Franklin Tucker wants to show the world while the world's watching. He wants to put on all the bad stuff and air all the dirty laundry out. And the state's trying to present a case that limits his ability to do that. And his attorneys are in a fight with him to say, listen, Tyrone, let us do that in a different form. And he's saying by that time, no one will care. It'll get kicked to the wayside. But what she should be saying to the jury, what my dad would be saying, you say to the jury is you talk about the fact that the defense has to prove nothing. That when we approach this case, you are to presume my client, James Crumbley, innocent. He's innocent right now. Walk across. My dad said he put his hands on the shoulders of his client. He'd say, my client is presumed innocent. He's presumed innocent. He's presumed innocent when he walked in this courtroom. He's presumed innocent right now. And he's presumed innocent until the state proves beyond a reasonable doubt each and every element of this crime. And let me explain to you how the elements of these crimes work. This is what they're going to have to prove. And explaining it, getting it in language for the defense and saying, we believe the state is not going to be able to prove each and every element beyond a reasonable doubt. They're not going to be able to prove, and then hone in on the fact that they will not be able to prove. They will not be able to prove. They will not be able to prove that James, they are not going to. Don't ever talk about what you're going to prove. My dad would say, I mean, I've watched so many trials with him on TV and different things, and that would bother him. He would immediately get very upset and angry about that because he'd say, that's what you don't want to do. Don't assert a burden that you don't have. You don't have the burden. And you want the jury thinking that way. You want the jury thinking that it's the state's burden. They have to prove they have to prove James Crumbley is guilty. They have to prove that James Crumbley didn't know. Right now, what she should have said is, right now, as it stands, right now, no evidence has been presented. So right now, it is your duty right now to assume that James Crumbley did not know and it was not reasonably foreseeable. It is the job of the state to eliminate each and every and all doubt. If one doubt exists, they've not met their burden. But right now, ladies and gentlemen, and that's what the opening should be about. What she just stood up there and did was she just goes up and starts setting all these standards. Well, now you got to come forward with it, because if you don't, and if you don't meet it, it looks bad in front of the jury. You've asserted a burden that you don't need. No, there are no links for my dad's trials, unfortunately. He has not, his last trial, and I'll give you a little background. Like you said, I'm going to tell his story. But the last trial he tried was back in, I believe it would have been 1995. Okay. That he would have been when he tried a case on his own. Now, essentially, my dad, we'll get into this. Why not? So my dad, was a very well-renowned attorney in West Virginia. Okay, he was involved. He started practicing law in 1973, and he's in the Eastern Panhandle of West Virginia. And he rose to great prominence as he began taking on cases and winning cases. And winning one of his first cases was in regards to a sheriff that got shot. The county sheriff got shot, and he took on that case. Now, he ended up losing that case, but he got it reversed on appeal. They tried it again for a second time, and he ended up losing that. But that gave him great prominence. The big breakthrough for him was a school teacher. It was a gay love triangle, which in the 70s, that was a huge thing in the area. But the funny part about that case was he got the school teacher off after 2 years. Then the guy that my dad accused of who he said actually did the crime, the police go after him, okay, and he goes on the run. He's in the state of Washington. He's on the national TV, and he says he gets arrested, and he says, "I want Steve Askin as my attorney." So they fly him back across the country. My dad represents him and gets him off. So, the guy he had accused in the previous case. So he beat the case twice with representing the guy that he was suggesting was he was the defense attorney. He was defense attorney. He did domestic relations, but he primarily did defense. And in the 80s, he was a big time attorney. Unfortunately, where my dad ran afoul. Okay. And again, this is kind of how we get into the interesting life story of myself and how I've ended up, why I didn't end up becoming an attorney myself. But my dad, he was a very, like I said, he was a very witting. He won a lot. I have my grandmother kept all of his, newspaper articles and things. And I am going to show them on here. I'm going to show you trials and stuff because we don't have video. At that time, they weren't doing videotape. West Virginia still doesn't put cameras really in the courtroom very much. Okay, nice, Cam. Where's she a criminal attorney at? What state is she a criminal attorney in? I guess I should say. Basically, he unfortunately, I guess it was in the times of the 70s, he made the fatal, and it truly did prove to be fatal. He made the mistake of using and trying cocaine. And then he tried it in November of 1979 was when he did that. It was Thanksgiving night. He tried it, and that became a monkey on his back that attached itself to him. Obviously, for a long time, no one knew about it. He's a defense attorney. He's representing people. He's winning. He's successfully taking on people, beating all sorts of cases, drug cases, unaliving cases. He had 106 felony jury trials, and I have to go look at the stats, but I believe, if I remember correctly, he calculated it up. I have to get it out. It's on. I have it in a box, and out of the 106, he had 76 not guilties. So he was which is a very big one. When I say these were felony trials. Now he had over 1,000, a couple thousand misdemeanor type bench trials and magistrate court cases. Those are the kind of run of the mill. But he did 106 felony trials. Like I said, he would be able to sit here and talk with you guys. But he was very, 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 very well renowned. He was considered to be by many today and to be the best attorney in West Virginia. And judges were scared of him because they thought he had a direct line to the Supreme Court. And he used to have his own pilot and plane, and he had a couple of times got on a plane and flew down and had filed a writ right in the middle of a trial and stopped the trial and got things reversed, got issues heard. So basically in 1994, I'm going on in my life, my dad, a bigger than life figure. And my parents had separated. So when I was, I think 5 or 6, but they stayed married for a while. But they had separated, and like I said, my dad was just a bigger than life figure. And then in 1994, unfortunately, an individual that was providing him with drugs got busted by the federal government. And my dad got called in as a witness. And the way they figured out that my dad was getting drugs from this individual was they had wiretaps. And at that time, cell phones were not as well known as they are today. They were like bag phones. And the way cell phones worked then was slightly different than the way they do today. And it was considered, they also had something called, which some of you may remember, portable phones. My mom used to have one. I think she still does, actually. But cell phones were considered to be um, portable phones were considered to be unprotected. In other words, you could use a scanner and listen in, but cell phones were protected. In other words, you had to have a warrant to listen in. So my dad alleged he wasn't. The government indicted the individual that was specifically to go after my dad because they were wanting to go after him. They indict the individual who was providing him with drugs and decide to call my dad as a witness. And my dad was then considered to be, that was pretty much the purpose of the case, was to go after him and attempt to bring him into the case and embarrass him and go after his law license and all that stuff. So ultimately, they achieve. They go. There's a big trial. It was all in the news. Of course, I was young. I didn't really understand what was going on. But they ultimately called my dad as a witness. And my dad, I remember, it was all over the front page of the papers. It was in the DC news and everything. So he comes over to the house, and because he was living in a separate residence at the time, he comes over and talks with me and my sister and tells us what's going on. And of course, at that time, he doesn't want to tell us that he's using drugs. He claimed it's all just kind of misunderstandings and things, and that there's these accusations because he's a defense attorney and he represents drug dealers, and people are saying, "Hey, he's using drugs." So, of course, I'm a fierce advocate of my father. I said, Dad, I got your back. Go get him. So he shows up in court and says, "I'm not going to testify because the only way they found out that I was, allegedly getting drugs from these people was they were listening to my phone calls without a warrant." Well, the judge said the government gave him limited immunity and said, he needs to testify. We're not going to prosecute him for anything he testifies against. But they essentially wanted him to admit on record that he was using drugs, which would have essentially put him in trouble for his law license. So the judge, because this was a judge that highly respected my father, said, "Well, I'm going to," again, this comes back to also an officer. You're an officer of the court. So if you're asserting something to the court, I'm going to assume you're asserting it in good faith. I'm not going to put you in jail. Normally, if you refuse to testify or you refuse a direct order from a judge, you will be remanded to court to jail until the end of the trial. My dad was prepared to go to jail on this issue because he believes it was a legitimate issue. So she says, "I'm going to hold you in civil contempt, and I'm not going to make you testify." And he had an attorney with him, and he heads out of court. He's jubilant. The press is coming. It was a huge thing, nothing like my dad had ever seen. The press is following him out. News cameras are following him out. And he makes the mistake of posing out front of the courthouse with a big smile on his face. And the next morning, when the U.S. attorney, who was a guy that, was a fierce adversary of my father, he takes it to the judge and says, "He's laughing at us, Your Honor. Look at him." And she says some curse words and says, "Go get him. I want him indicted of criminal contempt." So following the conviction, now all these people get convicted, and one of the things about criminal contempt is you have to show that you impacted the government's case. So all these people get convicted, and ultimately they end up going down. My dad ends up taking the case. He has several high-powered attorneys that are assisting him at this point, and they take the case down to the Fourth Circuit. When they get it down to the Fourth Circuit, the issue of whether or not the cell phone, essentially the Congress in the interim goes ahead and says that the cell phone is no longer protected. In other words, it's no longer an issue because the cell phone is no longer protected, that they can in fact listen to the phone calls. So the issue that my dad was going to raise was no longer, it had been essentially reversed by Congress. So this prosecutor, who was an adversary of my dad, goes down and says, it's a non-issue, Fourth Circuit. And the only thing the Fourth Circuit wanted to know was, do you intend to prosecute Mr. Askey for criminal contempt? Otherwise, we have to rule on it. And the prosecutor says, we don't. However, the prosecutor holds that out to the court. Remember, he's an officer of the court. He has an obligation and a duty to represent things honestly. But he holds out to the court that no, they're not prosecuting him. They don't have any intention. Well, guess what? They had a grand jury convened in Wheeling, West Virginia, that was hearing a case for criminal contempt, and the individuals that had just gotten convicted and sentenced to 30 plus years in jail were now ready to come in and say, hey, not only was he buying drugs from us, but he was providing us with intelligence he was looking up, he was using his resources to try to help figure out whether or not investigations were going on, whether or not there were federal agents following us, various different things. Essentially, he ends up indicted, go for a 2-year period. He's indicted of conspiracy to distribute drugs under the idea that he was providing intelligence to his drug dealer on how to keep the operation. He's a defense attorney, so they were saying he was providing them with intelligence on how to keep the operation secret and not get caught. And then 2, because he chose not to testify, that too was an overt act as part of the conspiracy, because he was trying to protect the drug conspiracy, and thereby that's why he wasn't testifying. Ultimately, they work out a plea bargain. My dad had some very good attorneys. They have a 3-day long sentencing, 2.5 day long sentencing hearing, basically over the issue. They wanted to lock my dad up for 20 years. My dad was saying no. He had a legitimate legal cause. That was the only thing he was trying to do, was challenge the constitutionality of the phone calls that they were trying to use as a basis for him to testify, that it had nothing to do with drug conspiracy. And the judge ultimately, after a 2.5 day sentencing hearing, did not find in favor of the government. He found that my dad was not part of a drug conspiracy, that he was not trying to do anything like that, but that what he was trying to do, but he also was not just simply trying to challenge a legal issue. He was trying to protect himself from the embarrassment of the public finding out he had a drug problem. So he sentenced him to 7 months in federal penitentiary, ultimately causing the State Bar of West Virginia to come in and take his law license at that moment, or he actually gave it up voluntarily. While he spent 7 months in jail or prison, it was a prison camp in Cumberland, Maryland. He came back. He ultimately had to litigate his license, and with the State Bar, they ultimately annulled his license, which meant he lost his license for 5 years and could reapply. He never did get his law license back. But what he did start to do, one of the attorneys that was helping him with his case, he began consulting. And he also began consulting with several other attorneys around, as he then began essentially a consulting business. And he became basically like a paralegal consultant, where he would consult with attorneys. Unfortunately, he stayed off drugs for about 5 years. And then in 2001, I uncovered that he was back on drugs. I found him using drugs and attempted to get him back into rehab. And that began a 24-year battle between my dad and I of trying to get him to get his life squared away, while he was also at the same time helping lawyers. He was involved in several cases that were of high renown, where he was consulting on the cases. He was in and out of rehab. He would have periods of time where he would get everything going really well, and then he would fall back off. And most recently, after a tumultuous, probably 7 years, the last 7 years were very tumultuous between him and I, we'd finally gotten him to a point to where, after a particularly bad incident last June, where he had fallen and was on the floor of his home due to drug use. He ended up he was, at that point, he had started to lose. He was kind of lost a lot of his balance. Because of cocaine use, it hurts your veins and things. So he actually had problems walking and stuff. So he walked with the walker at that time, but he fell. Ended up on the floor of his apartment. He didn't want anybody to call me, so He stayed there until his neighbor came, who lived up top of him. He lived in a house. He had a whole bottom of a house. It's a nice place, and he had someone that lived up top. They got home, and he's screaming, help me, and he sat there for 3 days instead of calling me. Eventually, I got called and became aware of the situation. I got him in the hospital. We got him fixed up. He had to go on dialysis because the muscles started breaking down in his leg. But ultimately, he and I reconciled our differences finally, which I'm very fortunate that we did. And it appeared we turned a corner. At least I thought we had. And that was when he and I told him, I want to get your story. And he and I were coming together. And like I said, we would always be watching cases. He'd be watching cases. Sometimes there were cases he was involved in. There was a couple cases down in D.C. that he was involved in that I was keeping my eye on. There was one in particular that did get filmed. He wasn't in the courtroom or anything, but there was Andy Jezik was the name of the attorney that was involved, and he was involved as a consultant on that case. And I remember watching it and keeping an eye on it. But ultimately, we decided. I said, I want to get your story. It's a hell of a story. I mean, it could be a Netflix documentary with everything that he went through, the rise, to fall, because there's a lot in between that I've left out of those 24 years after 2001. In fact, he became kind of like a Robin Hood guy. He literally started helping people as a way to fight back against the state, where he was helping people become pro se defendants for themselves who couldn't afford attorneys for nothing. It was for a meal. And my dad died pretty much with not a lot, mainly of his own doing. But we ended up the state. He was about to get his law license back, and that's a whole like I said, that's a whole story, and we're going to get into all of it. I'm going to tell the full story for him. But I helped him with the case. I ended up having to be his paralegal, and he had a full 3-day trial because they charged him with practicing law without a license because he was helping 10 clients, and they got wind of it. But the whole purpose of it was because he was about to get his law license back, and it's probably better that he didn't get his law license back because he really wasn't. Now, knowing what I know now, again, it was another time we thought he turned a corner, and he didn't turn that corner for very long. But at the very last minute, he was about to get it back. The West Virginia Supreme Court, he was getting calls from all over the state. Welcome back, Steve. And they indicted him. And it was misdemeanor charges, but they indicted him in circuit court. So we had a trial. The judge that presided over that judge was looking at a federal judgeship. And after she convicted my dad in a bench trial, 3-day bench trial, or 2 or 3 day bench trial, I have the transcripts out there. I helped him with his appeal. We took the appeal all the way up to state Supreme Court, took it all the way to the United States Supreme Court, got turned down. I helped him the entire way. We prepared pleadings, brief cases, did all that stuff. And I was kind of like his paralegal while I was also working and doing my own thing. But he ended up being well, so what I did professionally, essentially, I wanted to become an attorney. I mean, that was one of my dreams. I majored in criminal justice, and in my and I kind of took a little bit of a diversionary turn because I was going to be, that was what I was thinking I was going to do. And then fate intervened. I ended up being presented. I got to the end of my college. I was graduating, getting ready to graduate. And then my college girlfriend at the time, she ended up getting pregnant. And I ended up having to make the decision of what I was going to do. Now, at the time, my stepdad at the time was involved in the financial industry. So he said, hey, you go to law school or, get involved in the financial industry. And I said, well, then I'll take a swerve. So I got into the financial industry and began working for as a branch manager. Well, I got into a management training program and became a branch manager for a finance company. Did that for 15 years. Had a second child got married, had a second child, ended up, the marriage didn't work out because it wasn't really the right thing. Got a divorce. And then I met the wonderful woman that I'm married to now, and we got married, and now we have a 4-year-old. We have one on the way, so I've got 4 kids. So I'm well addressed with children and stuff. And I basically, kind of got to a point where I said to myself, as we had our little one, I was, my dad. Again, this is part of the story. My dad was, I guess it was in 2021 during the pandemic. My dad had the first incident where he had fallen and things were going bad for him. I had to take care of him. I had to step in, and I decided to, you know what? I want to step away from what I'm doing because I wasn't really completely happy. I was doing really well. I was doing really, really well with it. I was on a great path. But the concern I had was the path was going to take me away from the family. It was going to put me on the road. And I said, you know what? This isn't what's going to make me happy. So I didn't know what I was going to do. But I said I didn't like what I was doing. So we had money saved up. And I said, you know what? This is the funny part. And this is why I can say DoorDash, what they're saying. My middle child had we were putzing around, and he had heard about DoorDash, and he wanted me to sign up for it. So I signed up for it. And I said, you know what? Let me give this a try. This is a way to earn some money. And then with my dad in his situation. So I started doing full-time gig work, and then started trying to figure out, I actually have, believe it or not, another YouTube channel. Before I started this one, which is where I kind of got the confidence to start it. That is, I'm known over there. I was known as Dad Dash, or now I changed it to Rational Gig Driver. That's over there. It's a monetized channel. It's a small channel. And I post to it occasionally, but it was basically posted. You can see my whole journey through the gig economy. And, then everything happened with my dad in June. And I said, you know what, Dad, I think I've been, he knew I was doing YouTube stuff and making some money on that channel and making money out here with the different apps that I do with that. And I said, this opens the opportunity for us to do, and I was watching trials and listening to trials, when I'm driving around. I said, you know what? This opens the opportunity. And I really thought, I thought my dad had turned the corner. I thought he'd learned his lesson with everything, the dialysis. And I thought we'd gotten it. I thought we had him, as my son would say. We thought we had him. And then it didn't take long. He was in we were told if he went back this time, it wasn't going to take long. And unfortunately, he went back, it looks like about a month ago. And we didn't know. I didn't know. But it did not take long. And it got him. And that's what I think got him. That's what I got the call about. And that's why it's like he was 75 years old. He's older. He'd lived a long life. Even given all of the crazy recreational activities he was into. But it was still jarring and shocking because I really thought we had him. And I was like, you know what? I'm going to bring him on here. And he was excited about it. And I thought this is going to give him, he was getting very excited about it. And we were in the rollout. My son, my 18-year-old, was going to be there helping to be like the producer on his side because my dad was going to need assistance with all that stuff. And we had it all going. He was going to be rolling out this week because we were waiting for the Crumbley trial to start. Because like you said, my dad was the type that said, you got to get me the cases and the this and the that. So we were working on all that. And he was getting prepared for all of that. And it just wasn't, I guess, meant to be. So, but I got into this. So when I say I'm out working and stuff, that's why I have the remote ability to remote in right now. Obviously, I'm still out. I will still go out and I have to go do my gig work. So yeah, DoorDash is just as much of a job for anybody else. For those who want to, it can also be a part-time deal. but you can go out and make money. You can make serious money doing it. I don't just do DoorDash. I do about 11 different apps. And like I said, if you have an interest in what I'm doing with that, go over to Rational Gig Driver. And you can see me right over there. And you'll see my original journey with YouTube. So some of my earliest videos. But I'm talking about a totally different thing. And you see all sorts of stuff over there. But, that's kind of my little story in a nutshell. And like I said, I have a lot of a lot of fond memories of my dad, and we've been through a lot together. And I love my dad. He was a great dad. And the nice part about him was, even with all his craziness and all the things that he was into, he was a dad that always made it clear where you stood, and I always knew he loved me. So that was never a question. I've had a lot of people tell me in the last week, oh, your dad lied. I said, you're not telling me anything I didn't know. I like to hear it. I'm glad he was so vocal to everyone else, but he never left that unknown. I knew none of what ever was going on had anything to do with that. He was a good dad. He was a great dad. He was a great thinker. He was a great dude. He was still somebody, even when we were on the outside, I knew I could pick the phone up if I had a problem, and he'd talk with me about it. He'd help me think things through. He could, that was the thing. I think he was really, really, really good at solving everybody else's problems. He just wasn't good at solving his own. Yep, absolutely. It's the peaks and the valleys, man. It's but we will operate in in lieu, and I know he, like I said, I know he was ecstatic about this channel coming up, and he was looking forward to being more actively part of it on screen and getting a chance to talk and come out and speak and do all that. So he'll be doing it through me, I guess, from up above. But so that is the story there. Like I said, now I'm going to cover more of that. There will be, I've just got to figure it out on how I'm going to try to get some of the articles and things in and try to figure out how I want to present it. But we're going to be covering it because it's a really interesting story. I mean, it really is. He could have told it so much better than I can because he lived it, and there are things I probably will forget. And I've heard the stories, a lot of stories 1,000 times, but I'm sure there's a few he hasn't told that will now never get told. But I'll do the best I can because it's extremely interesting. And it's kind of one of these things where you look back at it. And when I think back at it, of course, I've been doing a lot of reflection and thinking about it. It's like, I can't believe that was real. Like, I can't believe we all did that. I can't believe that's where we were at. And now we sit here today, and, it's not over, but for him, his chapter is closed. My sister is in a turn. Okay. All right. Nice. So she, so I guess her firm probably doesn't just do criminal law. They do all sorts of law then, and she handles criminal. Is that how it works for her? But yeah, so, like I said, one of the things I learned from my dad is that, and again, from talking with him, is that, one of the most important things is watching this stuff, and that when people aren't doing the right things, they don't like you to watch it. So that's why we came up with the idea that we want to watch, and we want to watch and clip and watch and clip and bring attention, as much attention as we can to these things. And again, believe it or not, it makes a difference. Oh, they cover mostly criminal. Okay. And thank you, Dolores. I appreciate that. I'm looking forward to it as well. Like I said, to me, it's a passion project, so it's like, if I'm talking to one person, 6 people like we are right now, I don't care. I love it. I mean, if I'm talking to, and if I, have 50 people, that's even better, because to me, the way I see this is, and again, this is something that is extremely valuable. And this was kind of the concept. This is what my dad was coming out from and said, listen, son, this is extremely valuable because we are, look, we, you, me, everybody that's watching this channel, we are the jury pool. So attorneys will be very interested. And my goal is I don't want to be affiliated or paid by anybody, right, to cover anything. But what I would like to be able to do is have people, cases, individuals, and if you're a lawyer out there and you want to send me something to cover and present so that you can see how it lands with an audience, I will do it. And that to me is what is going to be potential exciting possibilities. That attorneys can come on and say, hey, let's watch this. Let's look at our coverage. How do we feel about it? How is and even if they're not sending us anything, just us watching the trials in general, that if we can get a big enough audience and a big enough base that we're sitting here watching and we're sitting here reviewing and we're sitting here asking questions and we get their attention to say, look, how's it landing? Because how it lands with us, we don't need a specialty, because every juror in this country that is going to be on a jury needs no qualification for being a special or to have a special understanding of the law. So we are very valuable to the system in the process. When the Rushdie case starts in Chattanooga, New York, you should stream it. Okay. What is the Rushdie case? I've not heard of the Rushdie case. I'll have to look into it. But yeah, I will definitely stream it. In fact, to be honest with you, that's one of the things I've been going through. Of course, I'm covering the Crumbley case. I'm going to cover the Tucker case. I kind of, looked along around, but I have built up, and you'd be shocked how many cases are going. I've gone around, and that was one of my goals. I've got 135 so far, and I want to have as many as I can. I keep my little youngest out of this YouTube area because I want it to be just strictly for me finding trials. But I have 135 different news channels so far that I found, and there are so many trials going on right now. So many trial feeds. He wrote a book, going to be very interesting. Are you watching the Ruster interview? It's on. Oh, Coat. Okay, no, I will. Actually, hold on. Let me find it. Thank you, Eon. We will definitely do that because I wanted to find it. Coat. News 7. All right, let's go here. Oh, look at this. The Rust attorney is on there too. Look at that. Dang. Thank you, Eon. That's exactly what I was looking for. Let's subscribe. First of all, welcome to the family there, Coat. And let's see what we can find here. Videos. Mother charged with abuse. Let's see. Oh, there it is. Okay, well, now let's see here. Prosecutor and Rust. We've watched that one. Legal expert reacts to guilty verdict. Let me ask you this again. Is it in the live stream that they interviewed him? Because I'm on the KOAT movie channel. Is it in that live? Is that where they got him? Let me see. Let's go in there and see. That's day one. Never mind. Hold on. What to expect for Alec Baldwin. Rest. Oh, wait a minute. Okay, I found another one. Hold on here. Is this... It's 2 minutes. Okay, here we go. I think I have something here. Give me a moment. Let's get back. Let's see here. Where are we at?
That was her job, to check those rounds, those firearms. And if no one wanted to pay attention or do that, then she could stop the work.
The defense argued the 26-year-old who did not take the stand was made a scapegoat and shifted the blame to Baldwin, who was handling the gun when it went off. They plan to appeal.
My sense was the evidence wasn't sufficient to convict, and it was a lot of guesswork and a lot of speculation.
Hutchins' parents and sisters say they're satisfied with the verdict, adding, "We look forward to the justice system continuing to make sure that everyone else who is responsible."
A never-before-seen video from the Rust movie set is raising questions about Alec Baldwin's conduct. During the trial of armorer Hannah Gutierrez-Reed,
Gutierrez-Reed's lack of checking ammunition similar to
They had to consider
the jury on day on one single fact.
Too much is just that never did the safety checks, never checked the rounds to pull them out to look at them, shake them. I mean, if you'd have done that, this wouldn't have happened.
Jury member Alberto Sanchez comparing Gutierrez-Reed's lack of checking ammunition similar to how he has to be careful with what he does as a CDL driver.
I have to check in my vehicle, make sure I'm not going to slam into people or do something like that. And that was her job, to check those rounds, those firearms.
After court, ABC News catching up with prosecutor Carrie Morrissey, who said it's hard to say she's pleased with the verdict.
Nothing's ever going to bring Helena back to her family. It was a hard-fought case.
All right, so there it is. That's all I could find, but I went on News Nation. So if you find it, right, I'm definitely interested. If you find the one that's more complete than what we just watched there, send me a link to Justice is a Process at gmail.com, and then I will definitely play it on the next show when we do it again, or I might even play it tomorrow if we have some time in between the trial. So one of the things I'm going to be communicating, I was talking about that with my wife today, because we've reached to the point of monetization and things of that nature on the channel. I am going to be trying to be more present in studio, as I call it, which is really an area I've carved off in my house that I broadcast from. But I'm going to try to be more present in studio during the day, during trial time, especially now that the Crumbley case is more is in my time zone, because I can be there 9 to 5 and then go out and do my little whatever I need to do. If I need to do gig work that night, if not, some nights I do, some nights I don't, and then be back. And again, probably be on between 10 and 11 with Justice Watch Live. I'd like to go off a little earlier because I know it runs late, and I think I might be able to get more people in here if I was running off a little earlier. So I'm going to continue to strive to go closer to that 10 o'clock hour and see if we get off at 10 o'clock, if that's going to make a difference. And like I said, this is all about just what we're doing right now, talking and watching some videos. And if you guys you guys come ready. I'm going to come ready with a few videos. You guys come ready with some videos. And if you want something to be up, ahead of time, just send it to Justice is a Process, and I'll make sure the next episode I have of Justice Watch Live, I want you to bring it. That's what my vision for this is, to have people watching all over the world, and that this show will eventually become part of that we can all come together. And I can only watch one trial at a time competently. I try to watch many, but I can only so if we have multiple trials going on, and then we bring everybody in, and we can continue to inform the world of what's going on, and we can each be taking on and clipping and cutting and bringing out the pieces and holding judges accountable for their behavior in the courtroom, and holding prosecutors accountable for their behavior, and defendants accountable and defense attorneys accountable for their behavior by clipping them and putting them out. And let me tell you, it can work. I've been doing this and this channel, and it's been amazing. I can't even believe we're actually getting close to 2 million views right now on this channel. And I opened this channel in November. And that's off of a majority of it is clips and shorts and small, in the clipping. And then there's some nice views on some of my videos, which is not as big, but that's what it's about. Those little small clips, clipping a judge who's getting upset, clipping somebody who's out of control. So you should do it as well. Make a clip, put it on your YouTube. If you have a channel, start doing it today. Because it brings attention and it helps trying to circulate things. So I think that's where we're going to leave it. It's 1:43 in the morning. So I think I know we've got trial in the morning at 8:30. So we're not getting the benefit of the Hannah Gutierrez case, which was a 2-hour time difference. So I was getting to do these late night streams and still getting some decent sleep. And I've got to make sure I get my rest. I mean, when you're especially when you're trying to do so many different things, and with everything that's going on, like I said, I've got a lot of preparation, a lot of stuff, a lot of things to prepare for coming up. So I got to try to balance all those different things. Let's see here. What do we got going on in here? He testified in Jayhawk court. Now he has his own page. Okay. Now, who is that? Who are we talking about? Are we talking about hanging out with the insomniacs? That's right. Hey, listen, I've always been a night owl. Always been a night owl. My wife takes she gets upset with me because she says, you got to go to bed. You got to get your sleep. So I try to get at least some sleep. And then, of course, like I mentioned, we have a little one on the way due in August. So I'll be definitely wishing for sleep when the little one gets here. Because, provided maybe he'll sleep tonight. My 4-year-old, we were lucky. He slept through the night pretty well. Nearly 7 a.m. Been awake all night. Okay. Hey, good. You know what? Sleep. Why sleep when you can watch and be involved? So absolutely, as long as you're being productive, right? Also, guys, take note. Unfortunately, I'm not. I made this. I'll show you all. Free Franklin Tucker, and I'm going to be wearing it in my Franklin Tucker. And then he took off in a truck, and it's Todd O'Quinn. Obviously, I made that myself. I'm not selling it or anything like that because it's not my right to do that. But I made it for myself because I want to have it as a prop. So I was wearing it tonight. It just came, and I thought, heck yeah, Dr. Joe Cochran. Okay. In the Jayhawk court now, he has his own page. News Station. Okay. Dr. Joe Cochran. And then this is the official hat. You can actually get this. This is you can get it in white or black. But this is the official Justices of Process hat. I had my little hat I made a while back. Got it off Amazon. But this is the official one here. Justices of Process, live streaming daily on YouTube. So you're seeing me wearing this now live that it came out. I'm going to get a white version, I think, too. It's just fresh out of the box. I got to clean it off and get it. So, Ty Tucker, he is stubborn. But again, he's stubborn with a reason to be stubborn. So, I mean, look, you got to understand that there is a method to his madness. Okay. He's not doing this. And that's why his wife ultimately understands this as well. I mean, she would love to have him get attorneys. But what a lot of people fail to miss with Ty Tucker, and it's tough for them to get it. And I'm trying to help it come through, but perhaps my videos are a bit long. So people, without watching the entirety of the video, it may not come all the way through. But what he's trying to do here is he's trying to out what we have in this case is a true example of corruption at its highest levels. And I believe, and I've seen the case files. I mean, I'm looking at the case files. You've seen everything that's been done here. And this is not this is not something that's just to the Ty Tucker. This was a course of business and behavior down in Key West for years. Again, I actually am going to, in fact, he interviewed attorney Nick Whitney and Greg Anderson a few times. That case has gone to appeal, and now Greg has submitted the defense attorney to the Florida bar. Okay. Gotcha. Nice. But his goal in this, I don't think it's the first. I think there's been it might be the first major one that was covered, but I do believe there was one a while back. I remember in my childhood watching it on court TV. I thought somebody did, but this is a rarity if he wins. But yes, it would be. It's a very rare thing that you should see. Like when I first saw the Ty Tucker case, I was like, oh man, this is crazy. I thought we had another individual out there. And then that was just going to go in there and embarrass themselves. And then I started to watch the case and I said, wait a minute, something's wrong here. And the first thing was that Malone IA report. I started digging into it and getting into the case file and reading through it and then having some discussions with my dad. And I thought, man, something's wrong here. There's something very wrong with this case. And sure enough, I'm glad I looked into it because there was. But that's the point. Ty Tucker understands that he could hire. Remember, this is a man of resources, right? This is not a situation where Ty Tucker is indigent anymore. He has resources. He has a wife who has paid, I think, over $1 million. I think she said $2 million, I believe, towards his defense. Okay, in legal fees. So this is not a scenario. And again, I think Ty Tucker, believed that people would understand this, but it's hard for people to understand this because they're not seeing everything, right? They're just jumping in. But the idea here is that Ty Tucker understands he could have an attorney. He and I, we talk back and forth, and I've tried to say, hey, get an attorney. And when I first came in, that was kind of my approach. It was like, hey, and he's like, and he basically explained to me and said, listen, I'm not, it's not like I know these things. I've been fighting this for 6 years and I know, but there's a reason for why I'm doing this. And the reason is a defense attorney would want to defend this case in a way that would have me win, but none of this gets out. I want to do it in a way that I try to tell this story. I try to show the world what they did to me. That's why he was trying to get that IA report out. That's why he was trying to get all these, spending all that time questioning. The problem, though, is that I see, and the concern I have is whether or not he has the ability to do that on his own in a courtroom without assistance if this judge sets him up in that way to do that, where without a hybrid type defense where he could still go in and push forward in his own way and still be the guy that has the final decision maker on strategy, but he's got the legal brain sitting at that desk with him who can say, do this, say this, go to this. This is the procedure for doing this. This is how we get this in. This is how you do this. We need to subpoena this. And then he can have somebody there who's helping him fully prepare for this case, issue all of his subpoenas, ensure that he can get in all of the evidence that he needs to get in terms of the IA report and the various different things, the Seth LeVay, motion to suppress, all these things. There's a way to get them in. They can get in, but if he doesn't know how to do it, these prosecutors are going to do their dirty tricks and they're going to keep it out. I don't believe anybody saw a ponytail per se. What they said was bushy hair and then bushy hair on the top and close crop on the sides. And Todd O'Quinn identified John Travis Johnson, otherwise known as JoJo, in a photo array on the 23rd, at the same time that John Travis Johnson was confessing at the police station or, was being bum rushed by Phelps and given 6 minutes of information. And then essentially, if we call it confessing, he was regurgitating that back. And then, of course, you've got the testimony of Paula, or not testimony, but Paula's statement, the picture, where she says, well, and he still, I think, even had a similar haircut going on when he was in court. But where Paula said she was told by friends of hers, by people that were close to them, said JoJo did this. And JoJo was John Travis Johnson's nickname. And he said JoJo's back in town, and JoJo was hanging out with Rory, otherwise known as Detroit. And that's the fit. I mean, you couple that in, and then the fact that Paula says she heard a car start up and leave. You've got Todd O'Quinn says he sees a guy running down the street, get in a truck and get out of there, as my shirt says. I mean, what else do you need at this point? That is all. Now, the problem is that sounds really great in a YouTube video. That sounds really great with us talking among each other. The issue is, how do you get all that before the jury? And you're not going to get all that before the jury because some of it's not going to be able to come in for various reasons. One of them being Paula's no longer here, so she can't testify or answer any more questions about what she was talking about JoJo or any of that. So as a result, some of it's not coming in. That's just stuff we know. But what can get in there is getting Todd O'Quinn in and then being able to, question Todd O'Quinn in regards to whether or not that body cam. Now, you got to be able to get the body cam in, right? So you're going to have to be able to get that introduced into court and get the body cam footage in, which I believe would have to come in by calling Officer Blake, I believe. Or you'd have to get the custodian of whoever was the custodian of the body cam records. You can get them in to verify that that is authentic. But, you need Blake to verify that that's all his authentic body cam. So he's got to come in. And then play that for Todd O'Quinn, have that there waiting, and then you call Todd O'Quinn. But there's, again, all these things have to happen in sequential order. And Tucker has to be ready to go, and he's got to be ready to subpoena these people, and he can't be showing up. He can't be showing up and going, without these things lined up. Yeah, right now, Ashish, we are discussing the Tyrone Tucker. There's a lot going on. You should definitely go back and look. We talked about a lot of things today, but currently the current topic, we were kind of almost wrapping it up, but we are talking now. We kind of got into our favorite topic, which is Tyrone Tucker, and talking about his case. Well, yeah, absolutely. Well, and here's the thing, Ian, even if he's found not guilty, people are going to, still doubt whether or not he's innocent or not. I mean, unfortunately, people will be are going to be skeptical, because a lot of times just merely being charged with a crime a lot of times gets people to suspect that something might be true or you might be guilty of something. So, for him, I think it's more or less what he wants out of this is he wants to go further than just people thinking he's innocent. He wants to get the attention of the Justice Department. He wants to get the attention of people within the state of Florida that can investigate what happened in his case. And then on top of that, go in and dig into the other cases that need to be dug into. We haven't even got into all of the suspicious deaths that happened at the Key West jail at the Monroe County Detention Center. Okay. Tyrone Tucker believes 110%, and he's told me this. He believes 110%. If he gets convicted, everyone, he believes that he will not survive. He's going to be killed before he ever makes it to prison, before he ever makes it to sentencing. And at first I was a little skeptical when he's telling me this, and then he sent me some some things that I have not yet released, and he told me to be careful when releasing it if I decide to go forward and release it all. But there are a lot of unanswered deaths tied to the Monroe County Detention Center. And that's why we got to be vocal for his behalf, because if they succeed in convicting him, then again, the deaths are situations where it appears that people in cells got their hands on items that under suspicious circumstances and then unalive themselves. And the sheer volume of the deaths where this has happened is concerning. And the sheer and how these people were able to get a hold of the items that they did to do what they did allegedly is concerning. So, this is some real stuff here. He's fighting for his life. And we're not talking about just being locked away. When they get him in there, they're going to want to put this to rest. And that's another reason why he was concerned that if his bail got revoked and he gets taken down there, and then they're going to tell the story to the press and everybody that he gets down there, he's been living this rich, privileged life, and the bail gets revoked, and he doesn't want to go on trial. So it was ready to be go time. If he gets taken into custody, then it's going to be time that we got to get our voices out. We got to be, and again, my footprint is what it is. I'm going to do what I can. My goal is to try to communicate, but if you see something like that, we got to be sharing and pushing and getting this information out there, because in the case of Franklin Tucker, his life will depend on making sure that these people don't feel comfortable that they can get away with something like that. And that's what we're dealing with here. And it may sound crazy to some of you, but I'm telling you, I've seen the experiences with my own dad's case with what people and entities and people are willing to do. Well, I don't think what he believes is they're not going to, like, if he would have been convicted in January, they weren't going to give him a chance to overturn it. When he got taken into custody, which he would have been taken into custody and put in the Monroe County Detention Center, he was never coming back out. That's what he believes, at least. And I believe him. Yeah, it's a possible future vid where I'm going to show some of the what I've been given, some of the documentation. It's the Monroe County Detention Center. If you look it up, you might even be able to find some of what I have online. It's all online, of course. By them meaning the Monroe County Sheriff's Office, who runs the Monroe County Sheriff's Detention Center, who have a lot of unexplained deaths on their hands. And I believe that, in my opinion, and Tyrone Tucker has expressed it, that he believes it's very likely that if he were to be taken into custody, that the intention would be that he does not make it back out, because once they get him, think of it. He's caused them a lot of problems. If he gets acquitted, if he gets this case dismissed, then it just gets worse for them. So their goal, and that's why their goal, and again, it really puts everything into focus here when you think about Mansfield and the statements he made when he said, we have a unique opportunity here. This is a once-in-a-lifetime opportunity. I'm thinking, what do you mean? Well, because they thought, remember, Tyrone Tucker rolled into town thinking that there wasn't going to be a JoJo, that JoJo was in the wind, and they were going to put on a case that was not going to survive the directed verdict, that the judge would have no choice but to direct an acquittal, because they wouldn't have had Travis Johnson, and therefore they wouldn't have had a case. And that's what he was prepared for. That's why he was so woefully unprepared. Shows up, John Travis Johnson shows up. He takes the bait. And they get a completely unprepared pro se defendant who doesn't have his subpoenas ready, who doesn't have his case ready, who doesn't know what he's doing. And when you think of it in that context, and you think of the fact that the best they could do is 8-4, and he gets a mistrial, if that doesn't speak to how weak and terrible this case is, Nothing else does. But they felt like this was their best opportunity for a conviction, and that they would never get another opportunity to have the circumstances in the deck stacked so much in their favor, and they still couldn't get the job done. Doesn't mean they still couldn't get the job done, even if it's prepared, because again, and that's why I think, I really do believe Tyrone really has to weigh the benefits of the idea of saying, I believe there are other ways, just like his attorneys explained to him. There's a civil suit that can be filed, and he's got other avenues. I'm sure there will be plenty of people wanting to provide him coverage on his case that will keep the pressure on. And if he files a civil suit and he gets acquitted, people are going to pay attention. People are going to pay attention to it. But I don't think he should risk, if he cannot have a hybrid defense. In other words, if he can't have people sitting at the defense table with him to help him through this and make sure he gets what he needs, I don't think he should risk it. I think he should just go ahead and let Jerry and Cara, I think that's her name, take the case back over and let them try the case and make an argue. Well, Eon, here's the thing. It all depends, because it depends on whether or not this judge takes it seriously or not. In other words, the motion to rehear, because he could say we're not going to hear it, and then Tyrone's going to file it. We're going to cover it. I'm being told it's over 100 pages long, and that might even be a problem, because unfortunately, there are limits and there are standards and there are maximums you can write. But he said it's over 100 pages long. I'm looking forward to reading it. It's going to get into all the dirty, juicy details of his case. We are going to broadcast it. We're going to read it together. We're going to go as long as we need to. We're going to read it. We're going to break it down. I'm going to be inviting, once I get through all of this. In fact, that was one of the other things I wanted to accomplish, was I was wanting to get Tyrone Tucker up here and have us have a discussion. I had a schedule in my mind, because what I really want to do for him, and he's been on some other interviews, but he's offered to come up and let me know anytime I want to have him up. But I really wanted to do this right for him, because what I wanted to do was have the audience already well prepared. In other words, I think the unfairest thing for him in a complicated situation that he's in, the most unfair thing that's done to him, is when he's asked to explain his case, or explain things, or why are you defending yourself, and do this, and he is expected to give a 5 minutes. It's expected to explain it all in 5 minutes, and that's not the case. So I don't want him to have to be doing that with us. I want to be able to put forth the understanding, put forth what he's told me, put forth the case to the audience that's there. And then when we talk, we can really get into a high level discussion with him. We can really dig in and ask questions that are not going to require him to have to give us the explanations that he would normally give to others that are not as well prepared. And we can really have a good discussion, and hopefully one that he can refer back to and say, look at this, and we really get into it, and we really dig into the case, and it really becomes clear and resounding, like it has for me in dealing with him and having talked and interacted with him through the various mediums we have, that, hey, this guy's telling the truth. And that's what we need. I'm surprised too, Dolores. I think the case needs much more attention. I'm doing my part in trying to do that best I can. Now, what I need from my audience is, if somebody sees this, and feel free to share it, feel free to play it. You will not get copyrighted by me. Play it, share it, get the word out, create your own medium, whatever. We need people talking about Tyrone Tucker's case. And I say that because, one thing you're going to learn about me as we go through this is when I get passionately into a case and believing in somebody and believing in their innocence, then that's it. It's on. We're going to get it done one way or another, as much as I can affect it. And I'm going to advocate for them. I'm going to talk with them. I'm going to, try to help other people to get as excited about things. And the fun part is I can now create videos and do things. And Tyrone Tucker's wife has put up all the videos and things that allow us to do that. I've got access to his case file due to Florida sunset laws, or I think it's just not sunset laws or sunrise or whatever it is, but sunshine laws. That's what it's called. That allows me to see the entire case file down there in Monroe County. So I can do that, and we can talk about it, and I know how to read a case. I mean, obviously I'm not a trained lawyer. I've not been but I know how to read a case. My dad taught me how to read cases, and I can at least read a case and tell you what it says and try to make sense of it. And what I've learned, the fun thing was, believe it or not, I used to love when I used to have access to be able to go into the clerk's office because I was part of clerking for a law firm that he was a part of. And I could go down there and get access to case files and see everything. And I learned how you can read. The funnest thing, it's like reading a book. All these motions, a motion, when you're battling an issue back and forth, the motion is essentially an argument on paper. And you can see this whole exciting battle going on. And in an appeal, same thing. Go up and start reading read appeal briefs, and it will tell you the whole case. It's really interesting. It's really fun. And then you can look at the case, and then inside that case are other cases, and you can look up those cases, and you can read those cases to help go along with your understanding of what's trying to be established in the case that you read. But and that's what we're going to do. We're going to keep the pressure on, and keep making sure that a positive spotlight is on this, and that these guys down there do not get to operate in darkness. And we'll be shining that light, even if it's only a few people deep. That's okay. No problem. But they know we're watching, and they're going to hesitate a little bit. And that's what I hope. So, so that's thoughts on there. So I think, guys, now that we've hit the 3-hour mark, I think we're going to get ready to call this thing. So does anybody have any final questions? If not, then I appreciate all 6 of you that are currently in the chat. Really do. I appreciate you guys all coming along and hanging out with me tonight. I am definitely going to make my best effort to be back tomorrow, especially since it's the end of the week. And we're talking about all the happenings in the Crumbley case tomorrow. I'm going to try to be present for as much as I can. I will probably have to do a little mobile listening. Thank you, Dolores. I did too. It really was. And it was actually really nice, guys. It was a nice escape. I'm glad I came on. I'll be honest. I was trying to get myself pumped up for it, and I was trying to get things. No, actually, Kim, I am in West Virginia, actually. I can anybody can access the Florida case files, because you can access everything. And then if you need to, you can put a FOIA request in, or even sometimes just put in a standard request and have it sent out to you. But in Tyrone Tucker's case, I haven't really had the need to do anything like that. But yeah, you can get access to everything you need. That's why Florida cases are covered so heavily. Because you can get in there. You can get into YNW Melly's case, the Adelson case, all of it. It's all right there. Now, transcripts and things of that nature you're not going to get. And like I said, there are things you can request. You can request videos and copies of videos, all that stuff. Western New York. Okay. Yeah. So you're probably about 6 hours from me, I think. 5.5 hours from me. Yeah, maybe not even that far. It might be 4.5. Yeah, not too far. No, because I'm down right outside of DC. Is where the part of West Virginia I'm in. It's called the Eastern Panhandle. But I'm going to check out that case, Cam, the one that you were talking about. What was the name of it? I want to make sure, the Rushdie case. So I'm going to check that out, because absolutely. And I was, again, once I get through all this that's going on with my dad and everything, and I'm able to get really focused in, it was my intention. It's my intention. We're going to have a primary case that we're covering, and I'm going to be following secondary cases. And, I'm going to also do some old cases where we're do some weekends where we're just sit down, and provided my wife's okay with it, to give me the time, we're sit down and we're just have a fun time where we're just going to sit here and binge a case, and maybe we take 2 weekends or 3 weekends, or we have a weekend case that we're due and watch it. I've watched the Adelston case like 3 times. And I, listen to it. Really, I don't watch it because I'm listening in the car, and I'll listen to it. I've become pretty adept at listening. I don't mind 2 times speed, but I know some people might not like that. For me, it's not been bad. When I first was doing it, I was like, this is tough to follow, but I've gotten good at it. So it's helped me to be able to cover cases and learn cases fast and get into things. I will say, yeah, absolutely. The email here, I'm gonna put it in Justice. And again, everyone, I'm putting this in the chat because, and I'll put it up on the screen here. That is the email, justiceisaprocess@gmail.com. Send me anything that you want. If you have a video you want me to cover on Justice Watch Live, that's what this forum is about. If there's something you want to watch, I'm keeping a active playlist. It's a private playlist so that nobody can see it until we're on here. But I've got it filled up with like videos after videos. Some of them may never get played. Some of them have already been played, but I'm keeping, as I'm watching or seeing, or I watch something that I think is interesting, I'm keeping it in there because, again, there might come a time when we might not have something to discuss, and we're just going to watch. That's the whole point of this, is to get together for an hour or two, talk about our primary case, watch videos, and talk about whatever it is we want to talk about, and just talk, just chat, talk, have fun. Eventually, the more people we get in, the better. And everybody's welcome. Every perspective is welcome. We accept all views here, even if we don't agree with them. That's one thing my dad taught me, was acceptance. We don't always have to agree, but just accept the fact that I feel how I feel and you feel how you feel. But always be willing to listen to another side too. So that's the principle that's going to guide this channel. We don't always have to agree. We don't always have to be on the same side, but we're going to be respectful. We're going to listen, and we're going to accept each other's perspectives. But don't be afraid either to try to sway you onto your side, respectfully, of course. And of course, I'm going to always be trying to sway you onto my side. But I will tell you, in my research and it's been incredibly helpful, especially as when I've been doing some of my videos on Tide Talker, getting the perspective from you guys. It's really some of it changed. Some of the thoughts, some of the questions led me to look into things and then help me understand things or see things that I didn't see. So please, if you disagree with me, I encourage you. I'm not going to be offended. I'm not going to be upset. I'm not going to be like, oh, you're blocked from my channel. Now, I don't want you coming. I don't want anybody, there's no need to do it disrespectfully. But, it's through disagreement. And my dad taught me that. It's through disagreement that we actually move something forward. If all we do is sit up here and agree with each other, we don't move forward. We don't grow. You grow through positive disagreement, positive, and there is a way to positively disagree, and there's a way to negatively disagree. So please, anything you see on here, offer it up. Offer me that alternative perspective. Get me thinking. That's the point. I want to get you thinking, get me thinking. And let's most importantly, let's have fun and just talk about this stuff. And like I said, watch the justice process unfold. It's really cool that we have the opportunity to have so many avenues and so many cases and so many opportunities to watch the justice system unfold right before our eyes. So yeah, I appreciate that, Cam. So send me that video, and then like I said, anybody else that has a video or something they want me to see, send it my way. I'll take a look at it, and we'll get it up on stream, and I will always attribute it to you. Provided you're okay, or if your email or something has an identifying piece of information that you don't want out, just let me know. And make sure I know your YouTube handle, and I will always attribute it to your YouTube handle. I will never violate privacy or anything like that. So don't be concerned about that. That's about it. So with that said, guys, I think we're going to wrap this thing up. I've had a really good time. It's been a real good break from everything that's been going on. It's one of my best nights I've had since last Thursday. So appreciate that. I appreciate that, guys. I appreciate everybody coming out. So I will see you definitely in the morning, and I'm going to make my best effort to schedule and maybe do a Friday night Justice Watch Live. We come together again, and whoever's available, come out, talk, speak. And in preparation, send me anything you want me to talk about tomorrow beyond whatever it is I decide will be our hot topic. In the meantime, guys, let justice prevail. And I don't know what I was thinking, but I kind of had a moment there. So I think with that, we will turn on the music, and we'll head on out.